Hello and welcome, everyone. I think we're waiting for some of our speakers for opening speech, but we can, I think, start meanwhile. Yeah. So our event is dedicated to international investment and international trade. So I believe this is hard to unnotice all the transformations in the trade and investment going on. Yeah. So this is and new imperatives coming up on the matter of the balance between investor and public interest, and this is all is interesting to examine and interesting to look through. And this is why we have the synergy of academia and the legal practice here, and also some of the representatives of the government officials to have that interconnection. So the methods that we're going to discuss also related to these aspects of law. Yeah, to introduction, please allow me to give a speech to the rector of Westminster International University in Tashkent, Dr. Bahrom Mirkasunov.
Assalomu alaykum. Avvalambor, hurmatli shu anjuman, xalqaro anjuman qatnashchilari, ruxsat bersanglar, men shu ingliz tilida deyishgan edi, bu yog'ini ingliz tilida davom ettirsam. Chunki virtual qatnashchilarimiz ham bor, bizani eshitayotgan. So thank you, Akbar aka, for your introduction. So colleagues, dear students, and dear guests joining us online and face-to-face here in our beautiful campus, welcome to the first Central Asia Law Forum, hosted by our commercial law department at the university. So this is very exciting. And why? Because we always wanted to put the commercial law department on the global map. So we're moving in that direction. And this is a recognition of the hard work of our students and colleagues who are doing a very good job bringing their knowledge and skills to the development of the country and the knowledge gaps and policy gaps in the country that exist for a while. So as you know, Uzbekistan is going through very hectic and big reforms in the area of investments and trade and personal private sector development and business law. So, and I cannot find any better forum to address this than Westminster International University in Tashkent. So this is why we're hosting this. Unfortunately, due to pandemic, we're doing it online and offline for 2 days in the afternoon. So colleagues from Europe and UK and the US and other places, Asia, can join us during the afternoon. So we have lined up very good lineup speakers, and they represent the private sector, international organization, leading law firms and scholars of law who are experts in the area of investment and trade and economic and commercial law. So we're very excited to have everyone and to listen to them. And I'll keep my speech short, and I just wish everyone to have a great time at this forum we're organizing for the first time. So without further ado, if Jovan Jekic online, I will introduce him. If not, I'll just move to our next speaker.
Mr. Jovan Jekic, we expecting you to start. So yeah, I think we need to go further. Yeah. Meanwhile.
Okay. So then let's invite our next speaker, Alim Ernazarov. Alim Ernazarov is the chairman of the Chamber of Advocates of the Republic of Uzbekistan. So, Alim aka.
Alim aka, please, you may start.
По-моему, слышно?
Yes, please.
Ассаламу алейкум, хурматли форум ishtirokchilari. Добрый день, уважаемые участники форума. Я благодарен организаторам и соорганизаторам сегодняшнего форума за приглашение выступить с вступительным словом. Конечно, я...
Ali Makia, just a moment. If you split your speech in the parts, we have a translator in the room, yeah, to translate to the audience. Да, пожалуйста, вот по частями, пожалуйста, чтобы успевали переводить.
Хорошо. Значит, я ознакомился, значит, с программой конференции, форума. Она достаточно очень интересная, и темы, и выступающие затрагивают такие инструменты, которые касаются, значит, инвестиционной деятельности, международных отношений и так далее. И я, пользуясь случаем, хотел бы по этой теме, значит, дать короткую информацию.
Один момент, Ali Makia, сейчас наш переводчик вступит, пожалуйста.
Good day, dear participants of the Central Asian Law Forum. I'm very happy to be invited to this forum. I got acquainted with the agenda of the forum, which touches the topics such as the international relations and investment law.
Пожалуйста, продолжайте, Ali Makia.
Да, я коротко, пользуясь случаем, хотел бы проинформировать о состоянии адвокатуры на сегодняшний день в Узбекистане касательно темы сегодняшней конференции.
Taking advantage of this opportunity, I would like to briefly inform you about the state of bar system in our country.
На сегодняшний день в Узбекистане осуществляют адвокатскую деятельность чуть более 4000 адвокатов.
These days, about over 4,000 advocates are practicing law in our country.
Да, вроде бы это и много, и мало, но тем не менее я хотел бы затронуть вопрос адвокатов, которые бы специализировались на сегодняшней теме.
And I would like to address the topic of the lawyers that specialize on the topic of today's forum.
На сегодняшний день в Узбекистане ни много ни мало небольшая прослойка адвокатов сформировалась, которые бы занимались бы вопросами инвестиций и международных внешнеэкономических отношений.
These days, we have lawyers who specialize in the investment law.
Естественно, значит, вопросы инвестирования, значит, они многосторонние и имеют свои различные, значит, сферы взаимоотношения в процессе инвестирования.
Naturally, the investment has multiple spectrums, and it has the interrelations with many different spheres.
Естественно, это касается и банков, которые тесно связаны с инвестиционным процессом, страховые организации, кредитные организации, инвестиционные фонды.
Naturally, it touches the organizations such as banks, the credit organizations.
Вот эти организации, значит, в большей степени, значит, в этом процессе сталкиваются с проблемами и вопросами, касающимися налогообложения, таможенных процедур.
While they're performing, they come across a number of different issues such as tax,
транспортной логистики и трудовых отношений процесса инвестирования.
Transportation, employment.
В этих процессах, естественно, те организации, которые я перечислил, я еще раз напомню, это банки, страховые организации, кредитные организации, участники внешнеэкономических операций и инвесторы, значит, чувствуют или у них есть необходимость в хеджировании своих инвестиций.
These organizations, such as banks and foreign investment banks and credit organizations, are interested to hedge their risk before they enter to the market.
И в связи с этим у субъектов этих отношений появляется потребность в получении профессиональной юридической помощи, в том числе со стороны адвокатов.
Therefore, they need the proper legal support, including from the advocates.
Мы сейчас вот и занимаемся вопросом повышения квалификации адвокатов в части их, значит, знаний и познаний и практики, касающейся инвестиционной деятельности.
We as the association, we organize the trainings for advocates and try to improve their skills and knowledge in the investment law.
Да, ну, я понимаю, что сейчас наш языковой барьер, он несколько нам дает помеху и в моем выступлении, и восприятии моего выступления участникам форума.
Yes, I do understand that because of the translations, the information that I tell you might be distracted and you might get some different information.
Я видел в программе, что сегодня и завтра будут выступать мои коллеги-адвокаты, которые уже, значит, в прямом общении, без переводчика, будут обмениваться своими мнениями. Я думаю, они скомпенсируют то неудобство, которое сегодня существует между нами, я имею в виду.
I can see from the program that there are few of my colleagues speaking English that will present, and I'm sure that they will compensate the information that I couldn't tell you while speaking in Russian.
Благодарю за внимание и желаю успехов в работе форума. Спасибо.
Thank you and good luck.
Алимаке, большое спасибо, что вы сегодня к нам присоединились, и будем ждать вас и ваших коллег в университете. Я тогда следующее слово передам Ламия Худаярова. Lamia Khudayarova is our alumni and graduate of our undergraduate and master's LLM in international commercial law. So thank you very much for joining us, and floor is yours.
Thank you very much for a kind introduction. It is always a pleasure to come back to WIUT. Good morning, good afternoon, dear colleagues, ladies and gentlemen. It is my pleasure to welcome you today here at WIUT. This is the first Central Asian Law Forum, but I have the audacity to say that an excellent platform has been created for considering perspectives on legal transformation, exchanging best international practices, and establishing further cooperation between the Central Asian countries and other foreign states in different areas. When I was going through the agenda of today's forum, I've noticed one particular pattern, that every theme included in the program of today's forum was related to economics and entrepreneurship through themes like investment, finance, and trade. And that actually didn't come as a surprise to me, because for the last several years, these legal transformations could be seen in the large-scale reforms which Uzbekistan is implementing currently in various spheres. And many of these reforms are in fact related at liberalizing and growing of national economy, driving force of which is undoubtedly the private sector. And therefore, currently, government pays a special attention at supporting and stimulating the private sector, growth of entrepreneurship, creating favorable business environment, attracting foreign investment, and most importantly, offering them full support and protection. These legal reforms and transformations could be seen in different aspects, be it an adoption of law on foreign exchange regulation, which introduced and guaranteed freedom of cross-border transactions, be it a law on investment activities, which ensures that foreign investors are protected from nationalization, be it an introduction of new tax law, which introduced lower tax rates and simplified reporting the requirements. There are different various reforms, and one of the reforms in which my office was directly involved is reduction of amount of licenses starting from the January of 2021. 70 licenses have been canceled, 35 permitting documents were simplified, and further 115 licenses were simplified. And in accordance with the current legislative acts, the priority of rights of business entities in all spheres of their relation with the governmental agencies have been ensured. Drastic increase of liability of governmental officials and governmental agencies for violations which they committed in relation to business entities have been introduced. Further, by the initiative of our president back in 2017, a special institution, Business Ombudsman institution under the auspices of the president has been created. This kind of institution was created for the first time, and the primary purposes of which is to ensure protection of rights and legitimate interests of business entities. These transformations which occur in Uzbekistan in the last several years, one more time demonstrate that the government is open to transformations and pays a special attention to provide full support to business entities and create even more simplified and favorable conditions for doing business in the Republic. Dear participants, current situation in the world has demonstrated one more time that all countries are actually interconnected, and presence of such open dialogue as today's forum is of great importance, and creation of cooperation between the countries is more important than ever. And therefore, in this regard, I'm sure that the Central Asian Law Forum will give a start to new perspectives, interesting ideas, and will play an important role in ensuring cooperation and as a constructive dialogue between Central Asian countries and not only, and with other foreign states. I would like to wish you further success, good luck, and interesting discussions. Thank you.
So, Lamia, thank you very much. I know what you're doing at the Office of the Commissioner for Protection of Rights of Entrepreneurs is very indeed needed right now to boost the protections for our entrepreneurs, which includes our graduates and other students as well. So without further ado, do we have Joe online? Okay, then we'll move to we're right on time. We'll move to the main. We have two keynote speakers who are joining us online. Christopher Hartwell and Yanis from the University of Westminster. But I'll pass on the word to Akbar, who will introduce the speakers and let them start their speech.
Thank you. Let me introduce Dr. Christopher Hartwell, who is the head of International Management Institute on the George School of Management in Law in Zurich. And he's also full professor in Kazaminski University in Warsaw. He's also full professor in the financial system in Beaumont University. And I think he's a very extensive titles Dr. Hartwell has. And I believe I'll try to grasp most of them. Yeah. So he's former president of Case Center for Social and Economic Research in Warsaw. He's also leading scholar institution in economic and transition. With more than 20 years experience in the public and private sectors around the world, he's advised governments in economic policy issues in Germany, Russia, Kazakhstan, Moldova, Poland, in a number of other states. He's previously worked in Warsaw. Previously, then Warsaw, he worked in Moscow as the head of global markets in institutional research, and at the Institute of Emerging Markets, based on the Moscow School of Management in Skolkovo. The research of Dr. Hartwell concerns importantly property rights, which is directly related to the protection of investment, yeah? And also macroeconomics, financial systems. And he writes widely on the international trade subjects and economics as well. And he serves as a reviewer to peer-reviewed international journals. He has taught and conducted trainings on the growth issues across the CIS. And he's worked for World Bank Group and for emerging market equity funds. He has a PhD in economics in Warsaw School and economics and master in public policy from the Harvard Law School, School, and also BA in political science and economics from University of Pennsylvania. He also author of the famous book of Institutional Barriers to Transition to Market from Palgrave Macmillan and Two Roads Diverge from Cambridge University Press. So without further ado, allow me to pass the word to Dr. Christopher Hartwell to start his presentation.
Thank you so much for that. I think the short version of that is I do a lot. The reality, I'm not at Bournemouth University anymore. I was formerly a full professor of financial systems resilience at Bournemouth, but I am not there anymore. Now I am full-time here in Switzerland. I am very, very pleased to be able to talk to you, and very, very sad that I am having to do it via the computer, because I love Tashkent, I love Central Asia, I love plov, and the fact that you cannot actually deliver me plov right now while I'm sitting in front of my computer in Switzerland makes me very sad. But I'm very happy that I'm able to speak with you guys today. Yeah, the previous speaker, the introduction was very, very astute in noticing that we talk that a lot of the things we'll be talking about today are economics and investment, because what you are doing is looking at things from a legal standpoint, but it has economic ramifications. And I am an economist, as you just heard from my 40 billion things that I do. And I want to talk today taking kind of an economic viewpoint on something that you'll be discussing, namely bilateral investment treaties. And I title it Opportunities and Challenges for Uzbekistan, but obviously it's much more than that. What I really want to do is explore some of the economic rationale behind having this specific vehicle that is utilized internationally. So what I'm going to talk about today, first, the basics. What's a bilateral investment treaty? You guys all know this. This is not something that's new to you, but I want to introduce some of kind of the rationale behind it, which you might not necessarily have thought about. And what is the institutional link? And I think this is key. Secondly, what are the opportunities for a country that engages in a bilateral investment treaty? We can also call them international investment treaties, IITs. We can look at what are the challenges and pitfalls. How relevant are they in either your particular case or in the case of any kind of emerging market? And then what should be the way forward for Uzbekistan and its businesses? When they say, should Uzbekistan be looking to increasing its number of bilateral investment treaties to improve its FDI performance? Now, I specifically and purposefully say it's businesses, because we tend to think, economists are definitely very, very guilty of this, but lawyers are as well. We think about like international trade treaties or regional integration at this macro level of what countries do. Well, we don't have countries, we have people. We have people that represent countries, and countries are this agglomeration of various interests and so forth. So we don't have countries, especially when it comes to trade. We have businesses, and we have barriers, and we have bureaucracies, and we have things like this. But we shouldn't lose sight of why we enter into treaties like this, why governments enter into these treaties. It's about improving business. It's about increasing trade. It's about liberalization, and it's about improving the lives of the country's citizens. So I have that there purposefully so that we don't lose sight of that going forward, because especially if you're doing economics at kind of the macroeconomic level, or if you're a lawyer who's bogged down in the weeds in terms of looking at the various clauses, sometimes we lose this focus, which is why I'm happy to be here as an economist speaking at this forum. Now, the novelty of international investment treaties, bilateral investment treaties, is that we didn't think about them for a long time. We had this kind of history of trade integration throughout the world, the General Agreement on Tariffs and Trade, and then the World Trade Organization, which is really about trade in goods and services. Investment, though, is important. We know investment is intertemporal trade. It's money that's the flip side of trade. We're paying for trade for tomorrow. We're paying for trade to today. We have to see kind of capital flows occur in order to finance trade. So in the 1990s, we have kind of this first approach towards incorporating investment into trade negotiations, trade related investment measures. It was part of the WTO agreement that came out of the last round of the General Agreement on Tariffs and Trade, GATT, the Uruguay round. The interesting thing, though, is that it was very much part of the kind of GATT approach. The GATT approach towards regional integration, towards global trade liberalization, was to remove barriers. It wasn't about necessarily getting more investment. It was about removing the barriers to trade. It wasn't designed to set multilateral rules on how investment could be attracted. It just wanted to reduce unfair treatment, national treatment, and most favored nation status, and how to apply that in an investment setting. It was really pushed for by developed nations, the US, Canada, to a lesser extent, the European Union. But we see that the collapse of communism, the fall apart of the Soviet Union in 1991, 1992, we have these waves of liberalization in the 1990s, and there's this realization, or well, it's not a realization, it's been a truth in economics since the 1950s, is understanding how important investment is. So we know investment is important, and productive investment is important for going forward. So how do we attract it? This is where investment treaties come in. They try and take it a step further from where TRIMS, as part of the WTO, left off. So not only are we dismantling barriers, but we're looking to attract investment. So we want to increase investment specifically by setting in place a protected regime for investors. How can we make investors feel safe so that they bring their money to our country? Now, there's still no multilateral approach. There's still no standard, some gold standard out there that says this is how the treaty should look like. They're fashioned by each country, although there has been a lot of iterative convergence with the various bilateral investment treaties kind of worldwide. So you see countries that are getting closer into what's included, but it's really, it's bilateral, so it only affects each other's country's nationals. Because it's bilateral, or if you have an international investment treaty that's kind of an appendage to a free trade agreement or a regional trade agreement, it can be done much more quickly. I mean, this has been the problem with WTO. It's expanded, and then probably it has encompassed some countries which are not actually free traders per se. So you have a lot of difficulties in getting everyone to move in the same direction. Well, when it comes to IITs or BITs, you have a smaller amount of countries that you can then utilize going forward. So you don't have to wait for the consensus of over 100 countries. What you see is with kind of the creation of this vehicle, boom, bilateral investment treaties and international investment treaties explode, especially in the 1990s. But you can see even after kind of the dot-com boom and bust and the Russia crisis in 1998, you bring down the level of BITs and IITs, but they're still increasing. And this data only goes up to 2018, which is the latest available that UNCTAD, the United Nations Conference on Trade and Development, has. But it's still pretty accurate because I don't think there was a lot going on the past year with the pandemic. If you look at the green line is the cumulative amount of IITs and BITs that we have around the world. So for 180 countries, there's about 3,450 of these treaties that exist. You see, they're really, really popular. That's the point that I want to give you, is that they're really, really popular around the world. Popularity has pulled back a bit since kind of the heyday of the early 1990s, mid 1990s, but we're still negotiating them. What goes into them, you guys are going to be talking about this later. You're lawyers, you have kind of a better sense of it. But from an economic standpoint, if we look at the United States model, you can tell from my accent, I am American. The US, like many countries, has this kind of model bilateral investment treaty, which it bases all of its subsequent treaties on. So there's no international standard, but each country kind of figures out what they want, and then they have this model, and that's what they negotiate. Most countries have a very similar model that kind of encompasses these attributes. You have most favored nation status or national treatment status for investment, if it's better, for the life of a firm's operation. So this is basically eliminating the discrimination against someone simply because they are a foreigner or because they are a foreigner from a specific country. Expropriation and compensation, this was mentioned before I spoke, kind of prohibitions against nationalization, or if there is nationalization, there is a clear path towards compensation. You can take your money out of the country. This is huge. Why would you put your money into a country if you didn't know that you could take it out? Seems simple, but it's in the agreement. Performance requirements restricted. You can bring your money into Uzbekistan only if you produce this much, only if you have this level of efficiency, only if you employ so many local workers. No, these are restricted within the International Investment Treaty, within the US model, BIT. You can choose your top management. Okay, you can come in, but you have to have my cousin, and he has to run your local affiliate. No, you can't do that, at least not by the tenets of the Bilateral Investment Treaty that the US negotiates. And then finally, and this is where we start getting into a lot of the kind of the criticism, which we'll get to in a bit, is that you can kind of bypass local courts, which are in theory and probably obviously going to have a bias in favor of the home country government, or in some countries, you know, they're kind of under the thumb of the home country government. So a firm can't get a fair shake. It can't get a fair hearing, a fair trial in the judiciary. So you have this alternate dispute resolution system, this investor state dispute settlement. Not every country has this. We'll talk about that in a little bit. Implicit behind all of this, and this is where I really want to make you think, is that there's something wrong in your country that you need to have this bilateral investment treaty. In countries that don't have kind of formal property rights, investment treaties act as this ersatz, this substitute property rights. If you can't have broad-based property rights for everybody, and there's a lot of economic research into this, going back into the 60s with Demset and Alchian, and then going back to 2003, there's a paper that is definitely kind of the tops in this, and I'm sure all of you know it. It's Konstantin Sonen's paper on why we don't have broad-based property rights, and basically that political elites, he being Russian understands this more than most, that political elites fight for just enough property rights to protect their property, and then they don't care. So that's why you don't have broad-based property rights. If you don't have broad-based property rights, though, you don't have the level of investment that you want. You can get it just from the elites, but who wants it just from the elites? Then you end up with oligarchy, again, as Sonen talks about in his native Russia. The only way to kind of break through this is to break through the political logjam and try and get to broad-based property rights, or maybe you can create some kind of bubbles of property rights. And once again, if you can't get all the way to full-on property rights, you fill the gap by having this bilateral investment treaty. If property rights are infeasible for all, maybe you can just do a small amount that are crafted for those who invest. And this is the same kind of thing that happened with free trade agreements. Like I said, if it's politically infeasible because the unions are screaming, because people are saying buy American, because people are saying we don't want foreigners taking our jobs, well, maybe then you have a free trade agreement which allows kind of limited liberalization. And then as people see the benefits of this limited liberalization, then you get further liberalization, because you can see that it's cheaper to get shirts from Indonesia than it is to produce it in Pittsburgh, that you can get higher quality, or that at least you get more variety. So the same kind of theory applies here, that people start to see the benefits of property rights. And even if you don't, though, you get the investment that you need for people to get richer. And then maybe down the road, people start agitating for broad-based property rights. At the same time, there's policy risks that come in with investing. This is all of what the international business literature is about. Why do some businesses choose certain countries to invest in? And a lot of it comes down to country risk, and it's unavoidable. I mean, especially you don't know the the environment. I mean, I know Central Asia fairly well, but in starting a business, I would know the kind of what to go through. I would understand the interactions, but I wouldn't understand, the exact steps and how to kind of work our way through it. So firms seek to minimize their external risk, and they try to go to countries that are predictable. Switzerland, where I am now, very, very clear rules applied to everybody. Sure, some of the rules seem kind of arbitrary, but everybody's got them. Everybody's dealing with them. So that's fine. You want to go to a place where you have predictability. What you have with international investment treaties is to minimize risk via this idea of credible commitment, that you are binding foreign governments, you're binding future governments within your own country, how to bind the government to agreements across space and time. Maybe you can minimize volatility. Maybe you can minimize political risk by having a government sign a piece of paper that says, I am not going to do this in the future. You can get volatility from normal democratic processes. You see it in the United States, where we've lurched from the more laissez-faire policies of Donald Trump to a very, very interventionist policy of Joe Biden, which is, really kind of throwing businesses for a loop. But investment treaties try to calm not just kind of your normal give and take, your normal swing, but try to stop these extraordinary swings of nationalization, of meddling in who you choose as a manager. And they want to bind future governments to policy. So in theory, this should minimize political risk. So what the bilateral investment treaty is doing is not just trying to say, Uzbekistan is open for business. Everyone should be coming here. We're trying to attract it. It's trying to fill an institutional hole that you admit exists. We don't have property rights broad-based in Uzbekistan. They are small scale. They may be informal. You do this to say, we will grant these rights that we know are good for economic growth and for bringing in investment. We will do this for investors, but in this case, only for investors. Now, how do they work? We've got a lot of economic work that looks at kind of the benefits of international investment treaties and bilateral investment treaties. Berger et al. These are all kind of economic papers, so I'll just go through them quickly. Some work, Berger, shows that the mere existence of a bilateral investment treaty helps increase FDI, especially if you include national treatment. Dispute settlement doesn't really work, but the fact that you have a bilateral investment treaty means you've signaled and you're open for business, and it has a positive effect on foreign direct investment. Egler and Merlo, 2012, found that BITs raise the number of multinational firms that are active in a particular host country. They have a positive effect on the number of plants per firm, so how large their investment is, as well as on FDI stocks and fixed assets. Kerner and Lawrence say that BITs correlate with investment in fixed capital, but very little else. And this kind of makes sense because you think about what is volatility going to hit? It's going to hit your fixed capital the most. You're going to spend a lot of money to get this gigantic plant up. That is, Coca-Cola is now, it's got their bottling plant there in Tashkent. This is fixed. This is a lot of money, and this is something that you can really get hit by political volatility. So Kerner and Lawrence say that especially this part of volatility is mitigated. Cohen et al. 2016, sectors with the highest sunk costs respond the most favorably to BIT. So this is the exact same thing. But they say that BITs may be less useful for development because the sectors that you have with high sunk costs are not necessarily the ones that emerging markets really need, because emerging markets need labor-intensive investments. So less in terms of capital intensity, more in terms of labor intensity. Bhagwat et al. 2020 kind of brings this together. And there's a lot of kind of contrary evidence, or not contrary evidence, but let's say no evidence. A lot of papers have looked at what we've seen, kind of the relationship between FDI and BITs, and found little or no evidence that they affect flows. Bhagwat says the effect of BITs is concentrated in target countries with medium levels of political risk. So if you can take medium to low, then you're going to get the investment. And says that BITs are ineffective for countries with very high political risk because no one believes that you're able to commit away from that risk. And they're unnecessary for countries with low country risk because if you don't have the risk already, well, then there's no real reason to have the investment treaty. I'm going to Switzerland anyway with my money. There's no need to have this treaty. Now, as I said, these are the opportunities. There's a lot of criticism of bilateral investment treaties. First, well, as I said, BITs are pledged to extend protection. They are creating a preferred class, investors. They're not just about removing barriers, they're about creating protections. So they've come under a lot of criticism. They center on several areas. I could spend a lot of time talking about these, and I have already spent a lot of time talking about these in Uzbekistan, but I just want to distill them. First one is that there's loss of sovereignty or policy space. I'll go into that one in a minute. The second is that it overrides democratic processes. Maybe we want to have limited property rights. Maybe we're all going to vote for limited property rights. What right does the government have then to make us have property rights? Sounds far-fetched, but it happens. They're discriminatory. Why do you have property rights just for this preferred class? Just because these people have money. Why do they get the benefits when I don't? Why not have property rights for all? And then finally, this idea of investor dispute settlement mechanisms and whether or not you can kind of override the state. And this is kind of part of overriding democratic processes. As I said, I'll focus in on this loss of policy sovereignty or space, just taking a look at my time. The biggest criticism of BITs is that they don't let countries do everything that they used to do with regard to state intervention. Credible commitment means that you have to commit credibly. It means that you can't do the things you used to do. Most emerging market countries follow some sort of selective intervention when it comes to investment, right? They want to have these big public works projects. They want to be able to channel funding. Investor treaties take away some of that space. This is mostly targeted at these kind of investment policies, these national priorities. TNI.org does a lot of work against bilateral investment treaties. That's where I take this quote from. International investment agreements also have the effect of severely limiting a host government's ability to design a national investment strategy that involves a tighter and dynamic regulatory framework for foreign investors. They were talking about Myanmar here. Basically, that you can't regulate as much as a government might want to, because otherwise you don't get the investment. The World Bank also interprets the fair and equitable treatment clause in most modern BITs to be an overriding obligation. So countries might be bound to such treatment, even beyond kind of national treatment and most favored nation. So this extends to really nearly every aspect of investment: intellectual property, license and permits, transfer of income, profits. You have to have fair and equitable treatment. And of course, some people get mad at this because now it looks like you can't have a license and permit policy. You can't have an intellectual property policy. Now, the rejoinder to this is that first off, economics is about trade-offs, right? At some point, you have policy sovereignty or you have investment, but you can't have both. If you could attract investment with sovereignty, why would you need a bit to assure investors that you won't actually use it? And in fact, if we look back at the history of kind of investment attraction, it's these tighter and dynamic regulatory frameworks which have been precisely the problem. Discretion, volatility from government decisions, too much state intervention. That's why you don't have the investment. An example here is that some clauses of BITs have derogation or opt-outs. They say if there's a crisis, then this doesn't apply. But these weaken the overall treaty because you can always have a crisis. You can always find a reason to worm your way out of the treaty. So either you're promising a way around institutional dysfunction, or you're promising only to delay dysfunction until things get really bad. And then, well, the dysfunction will come back. So in this kind of scenario, you might attract more investment, but you're going to lose people at the margins who are still worried about these kind of opt-outs. There is the famous picture of someone shooting themselves in the foot. Sovereignty is prized, but is it valuable? We have the freedom, and we should have the freedom, to do bad, dumb, and dangerous things. It's crucial in how we learn as humans. It's all we do as teenagers. We do bad, dumb, dangerous things. We push the envelope. The same type of freedom in a delegated authority, such as government, is not crucial. In fact, we expect perfection from government, and we should hold them to account when they are not perfect. It's like actually incredibly deleterious for them to hold on to this kind of freedom to do dumb things. Giving away the freedom to do dumb things via a bilateral investment treaty isn't such a bad thing. Now, there's another pitfall that I want to mention here quickly. Sri Lanka went through the investor state dispute settlement. This is probably something that you guys know already, but just kind of to recap. Deutsche Bank versus the Democratic Socialist Republic of Sri Lanka in 2008. Basically, Deutsche Bank and Sri Lanka entered into this oil hedging agreement, this financial instrument. And the main purpose was to protect Sri Lanka against rising oil price. The Sri Lankan Supreme Court steps in and says, no, this goes against the Constitution. You can't have this. And so bang, they abrogate the treaty and say that you can't do it. Deutsche Bank has spent a lot of money in this. So Deutsche Bank takes Sri Lanka to the investor state dispute settlement resolution mechanism. They say that the hedging agreement was a protected investment because they spent a lot of money on it. Sri Lanka fights this and says, well, first, the tribunal doesn't have any standing here. It was a standalone financial product. The tribunal says, no, that's not the case. The agreement created an economic stream of value that was akin to property. So they had jurisdiction that the Supreme Court stepping in and ceasing the payment did in fact violate the fair and equitable treatment clause. And so they argued in favor of Deutsche Bank and awarded them $60 million plus legal fees of approximately US $8 million. Sri Lanka attempts to annul the award, but is denied. So the thing is, if you enter into these agreements, sometimes they might actually go against you. Now, the effect that this had on Sri Lanka, first off, it made the government very wary because you enter into these treatments, you don't think, into these treaties, you don't think it's actually going to come against you. But it did. They took a wait and see approach towards further bilateral investment treaties. There's a desire within the Sri Lankan government to move away from BITs and to quote unquote establish appropriate domestic legislation to protect inward FDI, i.e., how do we get out of this? So they've introduced kind of selective adjustments. They revised their model BIT. They've clarified the legal text, basically so that they don't have the same interpretation by a tribunal in the future. On the other hand, if you look at the numbers that I have here, this only goes through Q1 2016, but that's all I really need. You see, 2008 is when the case happens. So the award 2009, 2010 is the global financial crisis. When we come out of the global financial crisis in 2011, 2012, FDI flows to Sri Lanka increase massively. You know why? Because the treaty worked. The treaty said, we're going to hold the government to account. If you look at the amount of money that came in afterwards, the 68 million that the Sri Lankan government had to pay was basically a down payment on commitment. It paid the money and saw better inflows because the treaty worked. It said if the government does something stupid, we're going to hold it to account. All right, stupid is pejorative here, but if the government does something against the treaty, we're going to hold it to account. And it was, in fact, held to account. So in the last 2 or 3 minutes I want to say, what does this mean for Uzbekistan? In terms of attracting FDI, Uzbekistan's the green line at the bottom. Europe and Central Asia, excluding your high income countries, is the line right above it. And of course, your neighbor to the north, Kazakhstan, is up top. Kazakhstan has natural resources, so of course, it has been much more successful in attracting FDI. What you see is that since about 2014, there's been a slight upward tick in net FDI as percentage of GDP. And I use this as a 3-year moving average to kind of smooth out the different kind of dips and troughs you have from year to year. And you see, actually, right now, in terms of its FDI as percentage of GDP, Uzbekistan is higher than Kazakhstan. It's higher than kind of the grouping of Europe and Central Asia, taking out the high income countries, but there's still more that can be done. So does Uzbekistan need to increase its FDI attractiveness? Now, Yaki 2010 has this great quote. It says, countries that refuse to sign BITs or allow them to lapse will probably not see meaningful reductions in investment flows. BITs are not magic wands, the wave of which produces with a poof and a cloud of smoke, a foreigner with pockets stuffed with cash. If developing countries wish to attract foreign investment, they probably need to do something other than sign and ratify BITs, which is right. However, BITs are a signal of reform intent. They say that you are going to do other things. They are a way for credible commitment. As I said, you can shed your socialist past like Sri Lanka did and show that a government is serious about investor protection. They can help the move domestically towards broad-based property rights. Again, if property rights work for investors, why not for all? And in a competitive world, they can actually be the difference at the margins between investors and non-investing. So in the world, especially today, post-COVID, all manner of emerging markets are competing for investment. So they're not a magic wand, but they're better than retaining control in 5-year plans and targeted public investment. It might not help immensely, but the lack of a BIT and reform commitment can harm significantly. So to conclude, the BITs and IITs can offer this way to paper over broader institutional failings by building these small-scale institutions specifically related to investment. They come in a variety of shapes and sizes. Oh, I am out of time. I got my timer going off here, which is good that I'm ending up right now. They come in a variety of shapes and sizes. They're often bespoke, which means we have opportunities and challenges across specific BITs. The evidence is good that BITs help to push investment, but it's difficult to disentangle this effect from other reforms. The worries about BITs are somewhat overblown, but they can be legitimate worry for a government used to controlling its economy. But most important, as I said at the beginning, is to not forget the goal. It's increased investment. Liberalization is the goal. Investment is the second order effect. In that sense, anything that helps to open up Uzbekistan's economy and make it an effective tool for Uzbeks to prosper and Uzbek firms to be financed should be adopted. And if it can help with the country's delayed institutional development, all the better. Thank you very much. Rahmat, большое спасибо.
Thanks a lot, Christopher. I think it's a lot of food for thought. Yeah, this proves that investments is really interdisciplinary. Yeah, along with this is why it's considered part of international economic law. Yeah, I think at this point we can accept questions. Yeah, from audience and from others. Yeah, or we can accept it in the end of our second keynote. Yeah, if you allow me. Yeah. Hello, Yanis.
Aha. Now I'm off mute. Hopefully you can all hear me okay. Good morning out there in Tashkent. How is everybody?
Thank you very much, Yanis. Yeah, so we coming to the second keynote, and yeah, allow me to introduce you to the audience, Dr. Yanis Navos. Yeah, he's a doctor and professor at Westminster Law School and researcher in the foreign direct investment. Yanis studied in so he's awarded his LLB in the Essex and LLM and PhD in University of Kent, and he is teaching after that in the has a teaching fellowship in the Seoul's University. Yeah, he's held lectureship in the Kingston on the contract law and in University of Reading in the company and commercial law. Yanis has published 2 books in the Routledge and a series of authors, authored series of articles in the law and development, law, economics, and investment arbitration. And he's currently researching in foreign direct investment. And his publications in the intersection of EU and FDI are particularly marvelous. And I think at this moment I can note that we have a joint research project, yeah, with Yanis that we are particularly proud of. So without further ado, so I'm passing the word to Dr. Glen. Please.
Hi. So thank you very much for inviting me to present today. First of all, I have to put together a disclaimer that has to do with the circumstances in which we're in. So I am connected from somebody's bedroom with perhaps an unreliable internet connection. So if at any point you see a blank screen, or I stop talking, or I seem to freeze, or the sound goes, or any of these things, then you will experience this in the same way as my students have for the last year. As I can see from the live feed that I've got on my screen from your room, there's a large group of you in the same room, which is a spectacular achievement, I have to say, because I cannot even remember the last time a lot of us have been in the same room. So that very well done. I'm assuming that in Tashkent you're no longer, or you've never been in lockdown.
Yes, we'll be out of it right now. So yeah, this is, I think, very much a virtue in our situation, so we can convene together, the meetings.
So hopefully next time, instead of me presenting remotely in this artificial manner and then having lunch on my own, maybe next time I can physically be there and have lunch with all of you.
That would be marvelous. Yeah.
Okay, I would like to thank the previous speaker, because he has effectively done all my work for me by laying out for you what you needed to know about investor rights and the way investor rights work, and also the whole logic behind investor protection. I have traveled a long way in my understanding of these processes, and when I was a little bit younger, I was very concerned about the effects that bilateral investment treaties and the dispute resolution mechanisms that come with them. I was worried about the effect that they have on state sovereignty, on the ability of states to decide what they want to do for themselves, and the ability of the public within those states to reflect their desires onto legislative outcomes. And I spent quite a lot of time looking at this and thinking about this, and I was expressing this concern, especially in the area of investor-state dispute settlement. Why is it that we can have legitimate policies that have got public backing, that they've been carried forward by politicians with a public mandate, they've followed appropriate processes, yet now a country could be faced with a superior level of law, something that operates at the level of international law, that actually prevents them from implementing those policies? Now, the answer to this, why should we have this, is already contained in the previous presentation, which is, if you want to do business with people, there is a price to pay. And unfortunately, the restrictions that come with bilateral investment treaties, or multilateral instruments for that matter, they are very real restrictions, but they're also very real restrictions that give you something. In a way that every contractual relationship has rights and obligations on either side, bilateral investment treaties and similar instruments, they will put obligations on either side. So yes, there's no point pretending that we have no loss of sovereignty here. We do. We have loss of sovereignty. We have loss of discretion. But every time that we want to do business with somebody, then we will experience this loss. And perhaps, as we heard earlier, this is something that we want to do in order to be able to benefit from increased investment, increased trade, increased relations with the rest of the world. So there can never be a situation that a state gets to, have their pie and eat it at the same time. You just cannot do the things that make your investment environment more attractive if you don't give something back. And the benefit of this, of course, is that if you use these instruments in international law to improve your investment climate, then the terms and conditions of the actual deals that you have are going to be more beneficial to you. So this is a little bit of background and again a link with our previous presentation. What is my current idea? My current paper is one that examines what happens if you get these things wrong, not only when you might have upset a foreign investor and they try and come and sue you, because this happens all the time. But what happens when you actually genuinely think that you're right and you should have the right to do something, and yet still you find yourselves violating some bilateral investment treaty? So the example that I chose to use to illustrate this dynamic is what our friends and neighbors in Turkey have done recently. Now, as you've probably heard, last year in July in 2020, the Turkish authorities decided to change the designation of Hagia Sophia, which is the cathedral in Istanbul. They decided to change its use from a museum to a mosque. Now, this was a project by President Erdogan that was long-standing. They have been trying to do this for a very long time. It has political, emotional, and religious significance for the people of Turkey. It equally has significance for other religious communities within Turkey and beyond. Now, if you don't know what I'm talking about, every time you Google trip to Istanbul, you're going to get two pictures. One is Hagia Sophia and the other one is the Blue Mosque. They're the most iconic and the most important monuments in a city that is, very rich in monuments and nice things to visit. Now, the particular site was built in the 6th century, and it was built originally as a Christian Orthodox cathedral. It operated like this till the Turkish conquest of Constantinople in 1453, and it remained a mosque from that point onwards up till the establishment of the new Turkish state. Now, Kemal Atatürk, who's the founder of the Turkish Republic, decided in his attempt to modernize the Turkish state and the perception of Turkey, decided to change this into a mosque, and it became so in 1934, and it has been a major tourist attraction in Istanbul since that time. Now, the problem that we've got here is that there has always been a perception in the country that Hagia Sophia should not be a museum, should be an actual operational place of worship. And the current government under President Erdogan, they had the desire to do this, and they've been working their way through the courts in getting back the capacity to do this. So they have this decision in 2020, where the Turkish Council of State actually found enough reasons to annul the decision of Kemal, and they have taken back the state decision, converting the mosque into a museum, and they brought it back to being a mosque. Now, the decision from the Council of State gave the government the power to do this, and the government promptly moved to actually re-establish the site as a mosque. Now, all this is great in terms of kind of the cultural and religious background of the place. And perhaps, I don't know if you've had the pleasure of visiting the site. It is a wonderful site, and regardless of whether you're going there for religious or for religious reasons or for tourism, is a wonderful place to visit, and I've visited myself. All this is a great backstory, but what does it mean for investment and Turkey's position as investor? Now, as it happens here, it wasn't free to go and visit the museum. You had to pay. And you had to pay roughly the equivalent of $10 as a ticket in order to be able to access the space. The people selling you the ticket were not the Turkish authorities themselves. They were not the city of Istanbul, but it was a foreign investor, because a Swiss company by the name of SIGPA purchased the rights to operate ticket sales for the Hagia Sophia site. And not only this, but they've got significant investment in Turkey from a number of sites. So they won a competitive bid that the Turkish government put through, and now they've got the rights to operate ticket sales across a large number of museums and other attractions around Turkey. The specific site is actually quite valuable, because even if you're thinking that $10 doesn't really sound like a lot of money, you have to think about the number of visitors that it gets. Hagia Sophia being the primary site, tourist attraction in Istanbul, turns around about 57 million US dollars a year. So this is quite a lot of money. They had 3.7 million visitors only in 2019. So all of this is a very significant investment and very significant income stream within a package that is quite larger. I mean, if you look at SIGPA's entire portfolio around Turkey, then it's almost 4 billion US dollars worth of investment. Now, the question here is, what happens if the government takes a decision such as this, that they're entitled to take the decision, they've gone through the proper process, they've gone through the courts have given them authorization to do it. Yet, taking this decision and converting use of the site means that now this company that has the right to operate the ticket sales can no longer do this. An obvious response from the point of view of the company would be to say, well, you know, part of our concession is not operational anymore. We would like to be compensated for a loss of income. Now, this was an issue that came up. It was actually raised by the opposition parties in Turkey at the time that the president took this decision. The answer at the time from the Turkish authorities was that they think that they're acting within the law, therefore they have no reason to compensate anybody for this. After the decision was implemented and it started being discussed in international media, the government again responded to questions in parliament, this time saying that in November that they've got no intention of offering any compensation to the foreign investor for the loss of the ticket sales from this site. Now, let's think about this in the context of international investment treaties, drawing from the knowledge that we gained from our previous presentation. If a country signs an investment treaty with a foreign country in order to entice this investment to come in, then they accept certain limitations to their sovereignty and certain limitations to what they can do. Nobody is saying here that they don't have internally the capacity to do this, but they promise not to do it in return of creating a more welcoming investment climate. In fact, this story here is not just between the foreign investor and Turkey, but is about the host country of the foreign investor, because SIGPA is a Swiss company and Switzerland does have a bilateral investment treaty with Turkey. And this bilateral investment treaty gives you the standard set of protections that we saw in the previous presentation. They're supposed to respect the rights of establishment of the investor. They're supposed to allow them to extract the money and take it back. They're supposed to provide national treatment. They're supposed to provide most favored nation treatment when that is relevant. And crucially, they're promising in the bilateral investment treaty not to expropriate without the payment of compensation. The question now for us is, from a legal point of view, what is the foreign investor going to do, because they're losing quite a lot of money? I mean, nobody would like to return back to their shareholders and say, you remember those $60 million we were making a year out of this site? Well, you can forget them because the government has kicked us out. This normally doesn't go down very well. Therefore, they will be thinking of their legal options. One legal option would be to pursue this through the domestic courts, but the domestic court is not likely to get you very far because Turkey has acted within the law domestically. If the decision from the Council of State had been that Kemal's conversion is perfectly legal and there is no justification for returning to the original decree from the 15th century, and President Erdogan had decided to do this of his own discretion, then there would be an issue within domestic law. However, this is not the case here. We usually present actions in domestic law assuming that the foreign investor is concerned about the capacity of the domestic court to deal with this effectively, or they are concerned about the independence of the court and the capacity of the judges to actually go a different way than the one that their government supports. This is not relevant here, because even if you have a court that is very efficient and very willing to look at contractual disputes and can do this in a relevant time frame, still the law that they're looking at makes the action perfectly legal from the point of view of Turkey. So there will be not a great deal of interest for the foreign investor in pursuing this action through the domestic courts. Now, also, the bilateral investment treaty in question does not require them to exhaust domestic legal options before they can access investment arbitration. They need to go through a mediation process, but they don't have to go through the local courts, because this is something that sometimes happens. So if the foreign investor has a decision from the government that has been communicated to them that says, we're sorry this has happened to you, but we do not intend to compensate you, and they know that going through the domestic courts is likely not to lead to an outcome that they want, then what are they going to do? What they're most likely to want to do is to utilize a superior legal obligation to try and find some basis in international law that they could actually force Turkey to pay them compensation for the loss. This is not a situation where they could force the Turkish government to take back its decision. Nobody's suggesting here that even if we brand this action illegal, a foreign tribunal, an investment tribunal at ICSID, for instance, would have the capacity to order a government to do anything at all other than the payment of money. So we're not challenging here whether Hagia Sophia is going to go back to a museum. It will not, certainly not under this government. But what the foreign investor will seek is not that. They will not seek a restoration of their concession. What they will seek is monetary compensation that reflects their loss. The question is now, can they actually do this? Has Turkey violated international law, taking all these provisions in mind? Or is there actually an exception where it regards to cultural and religious rights? Now, what I've done in the past, I am a little bit like a kind of investment treaty ambulance chaser. I mean, I go to investors that have gotten the wrong end of the stick with their deals with nations, and I try to check whether there's anything that they could do about it. Very often there is something they could do about it. For instance, I looked at people trying to sue the Greek government for the haircut on the Greek debt in the early 2010s. Then I looked at people trying to sue Spain for Spain having changed its mind about subsidies for renewable energy. Then I looked at our favorite topic here, which is Brexit, and whether people could sue the government for Brexit. So I always try to see whether there is something that foreign investors could utilize in order to force governments to behave in different ways, or to offer compensation where they have violated their legitimate expectations. So I'm doing the same thing here with Turkey, but there's something different about this, because the motivation is not economic. And I think this makes this case with Hagia Sophia, it makes it distinct from the literature that I've been looking at in other contexts. When people were suing Greece, they wanted their money back. They had their bonds cut in value. So they wanted 100% of the value. The interest was economic. When people were suing Spain, they wanted the totality of the subsidies that the Spanish government had promised to give them. People here that are thinking about suing for Brexit, they want to sue for the costs that they're suffering in the adjustment that they need to make in order to address the loss of access to markets and all the other stuff that we have with Brexit. But these were all decisions with economic outcomes, and they were all decisions which were primarily in the economic domain. The decision to change the use of the site from a museum to an operational place of worship has nothing to do with economics. The Turkish government felt that it had a religious and moral obligation to do this and to offer this back to their people. Okay, you could argue that not all their people are Muslims and would like to use their site as a place of worship in the form of a mosque, but you know, President Erdogan represents a specific segment of the society in there, And he felt that this is what represents his constituents' interests. So the interest is clearly not economic. Now, do we have within international law the capacity to retain sovereignty and retain this freedom of movement around these issues when the interest is not economic and when the interest is something else? Now, we've clearly seen from a stack of cases, plenty of them mentioned in your previous presentation, that when the interest is economic, investment tribunals are not particularly impressed. So if a treaty gives certain rights and certain expectations, and the government in question has agreed to abide by those rights, what it has also done is agreed to face the consequences if they violate those rights. And this is perfectly normal. We started off this presentation by acknowledging that this is a situation of give and take. You surrender a bit of sovereignty and you get better terms, you get more trade, you get more investment. If you decide to violate the agreement, then you should pay compensation. Again, when the interest is economic, this is fully understood. But what happens when the interest is actually cultural or religious? Shouldn't a country have additional rights to decide what it wants to do within the space it controls when it affects culture? I looked, therefore, in this paper what we know about culture, what we know about heritage, the protection and promotion of cultural heritage within nation states, and whether this would offer us exceptions from what we understand to be our standard protections that are offered to foreign investors. What we're looking for specifically is something within the domain of international law that says when you're taking decisions for cultural or religious purposes, you are no longer bound by these protections. The idea of exceptions from protection is not unheard of, but it is usually discussed in a domain of emergency. For instance, a country may need to violate the obligations in bilateral investment treaties in response to an emergency. There's a war, there's an earthquake, there's some other type of natural disaster. To bring it closer to what we're facing at the moment, there is a horrible pandemic. So countries might not be able to adequately satisfy the interests of investors if they're facing an emergency that they need to react to quickly and immediately. That's why we've got things in international law that are called, for instance, non-precluded measures. These are certain clauses that you find in types of agreements that offer exceptions from protection. Also, in specific bilateral investment treaties, we may have specific carve-outs from protection that say that when the government is, say, responding to a natural disaster or a security emergency or a health emergency, then it does not need to abide by these rules. This is perfectly well established both within international law, customary international law in the broad sense, and it is well established within investment treaties themselves. So we have two sources for these exceptions. One is general international law, and secondly is the wording of particular treaties. Now, within all of this, what is the meaning of cultural property? So what do we understand by this? And can it include sites, buildings, towns, and all the rest of it? Yes, it can, because cultural property and the protections for it are not simply for artifacts. They're not simply for items, but they can encompass entire areas, they can encompass buildings, they can encompass anything of a historical significance. So, what is the conclusion here? Do we have enough? We know for sure that Turkey has a bilateral investment treaty with Switzerland. We know that this investor is Swiss. So if they manage to satisfy jurisdiction on their identity and the identity of their investment, they would have access to the rights given to them by the bilateral investment treaty. So we know all this. They could well be protected investors. There's definitely a bilateral investment treaty. There's definitely access to dispute resolution at ICSID if there is any argument about this. But does this particular treaty or does customary international law give President Erdogan a way to say, yes, I have violated these investors' expectations, but no, I'm not obligated by law to compensate because I am serving a higher purpose. I'm dealing with cultural and religious rights. The answer to this, unfortunately, for Turkey is no, because what we're dealing with here is a much narrower topic. We're not talking about Turkey's ability to take decisions on religion and cultural issues at large. We are talking about the consequences of a particular action. The foreign investor is likely to come and claim that their investment on this site has been expropriated. What do we know about expropriation? Most treaties, most bilateral investment treaties prevent expropriation, but in what sense? They're not telling national governments, you are not allowed to do it. They're telling national governments, you are allowed to do it if you have a legitimate purpose, if you have followed appropriate process, and you're not discriminating against the foreign investor. And crucially, you can do it upon payment of fair compensation. And this is precisely the problem for Turkey here. Yes, they have a legitimate purpose. I mean, I may personally disagree and I would like the site to remain a museum so I can visit it. But, you know, it's up to them to decide. It is their own country after all. So they have a legitimate purpose grounded on cultural and religious grounds. So that's perfectly fine. They have acted in a manner that could not be described as discriminatory. It's not like they chose to get rid of this particular investor and they gave the ticket sales to the city of Istanbul. Nobody has to pay for a ticket anymore, so that's fine. The problem is they don't want to pay compensation. And the requirements that you've got both in the particular bilateral investment treaty and in general interpretations of investment standards is that in cases of expropriation, the payment of compensation is an obligatory requirement. So you are allowed to expropriate if you've got valid reasons, but you can only do this if you pay fair compensation to the foreign investor. So my problem here and the investor's problem isn't the fact that Turkey took the decision to change the use of the mosque. They did this within their national legal provisions, and that is fine. The problem comes from their decision not to compensate. So the result of my analysis, and hopefully you can see the paper, either it has been distributed to you already or we can supply you with a link so you can download it off the internet. The conclusion of this paper is that Turkey has breached international law, but not in the way that most people think it has, because there's a lot of debate in international media saying that from a heritage point of view or for cultural reasons or for other areas of international law, Turkey has done something wrong. I cannot tell you whether this is the case or not, but for the case of investor rights, I can tell you with a degree of certainty that they have breached international law, not for their decision, but in their refusal to provide compensation. Now, and I'm coming to the end, I think I've spent half an hour, so I think I'm coming to the end of my time now, but I will leave you with this question. Do we think that the investor is actually going to pursue this? There has been almost complete silence from the point of view of the investor. Now, why is this? As I told you at the beginning, they won a package of investment in Turkey for which they've paid $4 billion. So when you've got a $4 billion investment in a country, your interests are much broader than perhaps a loss of 60 million out of that. So I think the reason why we haven't really heard much from the foreign investor in terms of what are they going to do there is because they have such a larger investment that picking a fight with a government is probably not in their best interests. So it is possible that they're negotiating in the background to have some sort of compensation in some form for the loss of this particular site, but they probably wouldn't want to upset the government and risk their entire investment. But never mind SICPA specifically, right? They might have their reasons to keep quiet about this. But what about everybody else? And this, I think, links nicely with what we had in the previous presentation. Now, perhaps the audience can ask us a few questions about this. What is the purpose of investor protection in international law? It is to encourage investment. And when the states show unwillingness to play with the rules, when they show unwillingness to respect the rights that they themselves promise to the foreign investors, what does this say about the investment climate? So I would be asking President Erdogan whether this is a good strategy going forward. So even if he is 100% convinced that this was the right decision in the summer of 2020, what it says about the behavior of the Turkish government and its attitude to foreign investors more generally, is this a good decision to make? Or would it be better for the long-term interests of Turkey to actually compensate this foreign investor so they're not breaching international law, and then send the message to the rest of the market that Turkey is a good place to do business in and people should feel safe coming and invest in the country? So I will leave you with this thought, and I would be more than happy to discuss further and have some questions from the audience.
Okay, thanks a lot, Yanis. I think, yeah, thank you. And this applause actually can again a signifier, yeah, of the interest of the topic. Yeah. So yes, very interesting aspect of law, especially the public purpose defense. Yeah, that normally and the question about whether this protection of cultural and religious right can add into the public purpose defense, or it's rather a trivial situation of a no compensation and expropriation. So because without compensation, normally there's no lawful expropriation. Yeah. Yes. So I think we can have some questions from audience. Right. Then, yeah, if you allow me to raise a question. My question is to Christopher. For Christopher, first of all, regarding the BATs, because BAT is considered as admission tickets for the state to investment. And however, we can see the wide variety of states who are joining BAT, yeah, globally. And the question is whether BAT serves its purpose. I believe that's one of the important questions nowadays. Yeah, I believe that the outcome coming from this discussion is that BAT is not the only the mechanism, but should. So is it still goes to the problem of the investment facilitation in terms of a consonance of a BAT with something state doing in terms that is reflected across the national policy and the national law. Yeah, I believe this question is somewhat more contemporary and yeah, cutting edge. So yeah, please. I think at this moment you need to unmute.
There we go. Okay, you weren't letting me unmute. Okay. Yeah, no, it's a very interesting question, and I think it has the analog in international trade. Do you have to have a regional trade agreement, or can't you just liberalize on your own? And that's why I tried to focus on kind of the political economy point, that you can't necessarily liberalize unilaterally liberalize when it comes to trade, because you have specific interests within the economy. And one of the things that economists love to talk about when it comes with trade is that the costs are concentrated and the benefits are dispersed. And this is exactly the same thing you see with investment. So, I mean, you could, in theory, undertake a reform package if you had the political will that would on its own attract investment. I mean, bilateral investment treaties are new. They're only come about since the mid to late 1990s, and countries did actually get investment beforehand. How did they do it? Well, they did it by creating these kind of broad-based property rights. Or if you kind of look at East Asia, because they created narrow property rights, but there was an implicit kind of agreement that there was going to be this protection for investors. And that comes from the kind of credible commitment that you can only build up over time. The problem is that you want to develop now. You want to have investment coming in now. Then the bilateral investment treaty is a vehicle because you've signed your name to a piece of paper and it is legally binding and it does have these specific dispute mechanisms. But if that's not, if that's not what you're looking forward to, then you just have to be good over a long period of time to build up the commitment. The funny thing is, though, is that without kind of the bilateral investment treaty, is that you can spend time, and this happens for firms as well. You spend years building up your reputation, and then something happens and poof, it's gone. Whether it's something like the Asian crisis, 1997, 98, you claw your way back, but it has a real cost in terms of investment, in terms of growth, and then in terms of kind of human development as well. So I don't think you need to have a bilateral investment treaty, and I think there are negatives that come with it. And I think Yanis's presentation was very, very interesting in terms of thinking about kind of cultural exceptions. And that's the other thing, is that BITs we're still kind of figuring out what to put in them. You're finding that governments are getting then challenged on some of these things that they hadn't even thought about, kind of cultural protections. But you know what? You have that in international trade too. You have carve-outs and exemptions for national security, although that one can be stretched. But something like cultural exceptions, you kind of get iteratively towards maybe some kind of collaborative approach to, this is exactly what we need as investors, and okay, we don't necessarily need the cultural side. I'd also like to note that Yanis and I have adjoining chapters in a book released last year by Routledge, Political Economy of Central Banking. He was before me and I was after him, so it was nice to actually have it flipped this time around.
Congratulations with the forthcoming book. Thanks a lot. So yes, we have questions from audience. Still yet? Yes, please. Microphone, excuse me. You got a hand? Microphone. Oh.
Thank you for the lectures. I'm from the Academy of General Prosecutor's Office. I have questions to both lecturers. Due to our law firm concerned on legal aspects, not only economics, so I want to ask one question regarding the legislative system. So, as you know, Yanis got a very beautiful sample of Turkish policy of changing the mosques to museums to mosques and other samples. So my question is it a threat to the unsustainable legislative system? So rapidly changing legislative system for the investors. In the other hand, the unsustainable government's policy for the investors. So for example, government adopted a law on property protection, and then some later government can adopt a new law. So investors can be afraid of getting investments to a certain country. So my question is about the threats of changing legislative system. Thank you.
Okay, shall I take that one? Yeah.
Yeah, I think because question is stated at the beginning, in the legal point, I believe, yeah, that's going to be more appropriate.
Well, I think the best way to look at this is what I mentioned before, that the international framework for investor protection doesn't actually prevent you from doing anything. It just puts a cost to it. Think about it this way. in London, where I live at the moment, you're not allowed to do a great many things when you're driving around. You cannot follow a bus in a bus lane. You cannot park somewhere where you have two yellow lines next to the pavement. You cannot actually park your car anywhere without a man with a hat appearing and, you know, asking you to pay for a ticket. It's incredible where these people are hiding, but they're everywhere. So how should we understand these restrictions? Am I allowed to drive on the bus lane? Am I allowed to park wherever I want? I could take the view that yes, I am. It's just that every time I follow a bus, I pay £60 for the privilege. Every time that I park myself on a yellow grid, I pay £80. Every time I choose to leave the car because I'm in a hurry and I don't want to discover where is the paying machine for the parking ticket, or my app on the phone doesn't work for me to pay the ticket, then I pay £60 instead. So I could view all these, instead of restrictions, I could view them as a fee for a premium service. So what we could tell people who are concerned about limitations on sovereignty, we could tell them that this is not really taking away your democratic rights. This is not really negating democracy, as a lot of the campaigners are saying. But what it does is it means that you are paying for an extra ability. And your extra ability is to do whatever you want as regards foreign investors, so long as you compensate them for it. Now, clearly, this is an oversimplification, and the amounts involved in investment disputes are huge. So a country could well say that we cannot afford to do something like this because it's going to be too expensive. But I think there's a perception that investment tribunals by default favor the investor, when this is not necessarily the case. If you look at the cases that investors win as opposed to the ones that the governments win, the governments actually win quite often. And I was telling you before about the cases with Spain. At the beginning of this, where all the foreign energy providers in Spain sued the Spanish government, we were a bit taken aback, and everybody thought Spain is facing a financial crisis. Even if it is judged that they have violated investor expectations and their legitimate rights, is it actually correct that the system results in all this compensation being paid to foreign investors when the country itself clearly cannot afford to be doing this anymore? Well, we shouldn't have worried that much, because few of them won, of the foreign investors, but then they had their decisions overturned on through some sort of appeals process, or the majority of them simply did not win, and they did not win in amounts in compensation what they thought they were going to win anyway. So that's the way I approach the question. It's a matter of cost. It's not a matter of capacity.
If that answers the question. Yes, so we can take, I believe, one more question. Yes, please.
Hello, Mr. I have a question. It's in the case of Turkey, you said that the expropriation was direct expropriation, not regulatory taking. But in both cases, there is a criteria for public purpose. So I would like you to draw some difference between the criteria of public purpose of regulatory taking and the criteria of public purpose of direct expropriation. What is the difference between public purpose of these two cases?
So I believe the question is whether it can be likelihood of its being regulatory measures rather than or.
So in the case Turkey tried to say that this was regulatory taking and no compensation, yeah? But I think investor found it as direct expropriation. For this reason, compensation was required, yeah? So I would like to have I would like to differentiate what is the difference between public purpose of this regulatory taking and expropriation.
I believe it's less about regulatory measures, but regulatory taking. Yeah.
was that specifically for me? Yeah.
This for you.
Is it for Yanis? Yeah. Okay.
I took it as a given that Turkey will be able to say in my example that they have a legitimate public purpose. And whether you brand this expropriation as a direct taking on or indirect expropriation, it doesn't change the fact that in both cases they're mandated to pay compensation. So I didn't want to go down the route where I'm challenging the logic of the decision. And genuinely, to be fair here, because I think we need to acknowledge what has actually been happening, I don't think that Turkey has a problem with this particular investor. So this isn't an issue of discrimination. This isn't an issue of some sort of bilateral country dispute that has expressed itself as animosity for a particular investor. I think Turkey, for what it looks to be doing, is perfectly happy with SICPA running the ticketing on all its other sites. It's just bad luck that this company happened to be running Hagia Sophia as well. So I think the problem is definitely not targeted discrimination, is not a direct expropriation in order to disadvantage a particular investor. So we have a legitimate public purpose and a legitimate rationale behind it, but it doesn't matter because the way that the rules are structured, all of this can only be okay upon the payment of fair compensation. And we see this in the case law. And if you look at my paper, I list a series of cases where similar things have happened. Either a direct expropriation or an indirect expropriation, so long as it's branded an expropriation, can only be acceptable if it is compensated fairly.
Yeah, I believe what's common with indirect and direct expropriation, in the end of the day, they are both expropriation. I mean, can it up? Yeah, absolutely. And that particular aspect about whether investor acting for the economic reasons and for non-economic reasons, that's, I think, particularly have a very interesting dimension, I believe, overall. And about the presentation of Christopher as well. I think that a marvelous interconnection between the property rights and investor rights, because I think in the BATs it's largely being underestimated, that link of the property rights. Although property rights are very much universal and decentralized concept, I believe this might be related to the fact that BAT is more concerned with the standards and expropriation per se, rather than property rights. Therefore, I believe no much emphasis to this property, so rather than a shortcut. So I think we are running out of time, and at this moment, I need to thank keynote speakers, marvelous presentation, and amazing interconnection between the topics that we really appreciate, and audience as well. Thanks a lot, Christopher, Yanis. Yeah, absolutely. And
Thank you.
Please stay with us in continuation. We're having a break.
Yeah.
Okay, please inviting to coffee break, everyone. Thank you.
Okay. Yeah, to those listening to online, apologies. Apparently the microphone was off. So good afternoon and welcome. And I've been talking about green finance, basically, mentioning products and services such as alternative investment funds. With this slide, you can see some of the, not all, but some of the initiatives, taking place in a global level, EU level. UK, since it's not a part of the EU anymore, is developing its own regulatory and policy framework. And I'll briefly talk about a so-called ESG investment, environment, social, and governance. And yeah, that it all started with this Paris Agreement. I mean, it started before that, but it picked up momentum with the Paris Agreement, where states undertook certain obligations to cut emission levels and thus to mobilize funds directed to facilitate these projects. UNEP Finance Initiative, Principles for Responsible Banking, another non-legally binding global initiative, which at the moment has about more than 200 banks signed up to this initiative, which basically identifies environmentally friendly projects, so the banks can direct their funds towards those projects. Now, EU level is quite interesting. Now, EU is they have set up an ambitious plan under the Paris Agreement to cut emission level to zero, until 2050. So that means until 2050, EU wants to become a carbon neutral continent, meaning that no emission from their economic activities. For that, they in 2018, they adopted a so-called EU Action Plan on Financing Sustainable Growth, which is EU's commitment to channel private financial flows to investment that support Paris Agreement target, which is carbon neutral Europe by 2050. EU taxonomy regulation is unique because this shows a shift from non-legally guidelines type of documents into the regulation, into the legally binding regulation. Now, taxonomy is basically is a tool, is a system which helps to the financial institutions to identify environmental projects, which is economic investment activity, but with less or minimum or even zero environmental footprint. UK is planning its own taxonomy, as I said, because not part of the EU anymore, so they need to come out with something on their own. UK government sovereign green fund, expected 2021, is I think its first sovereign green bonds being issued by the state. Now, what green bond means, Shukrat will tell us later on. Now, global ESG discourse, quite fascinating phenomena, environment, social governance. Now, what it means, previously, when fund managers receive the fund from asset holders as on the basis of trust, basis of fiduciary duty, they had responsibility. Now, that responsibility was to look after the best financial interest of their clients. So if someone trusting their money, so I can put it somewhere, so all I had to do is to make sure that this will yield investment return for my client. This was a best financial interest, but this is changing now with the ESG. Now I have to look at not only financial interest, but possible environmental, social, and governance issues. Now, when we say governance is, corporate governance, I need to make sure that the company I'm investing is rightly managed, rightly governed, no corporate frauds, etc., etc. So what I'm doing here, I'm looking at risk. I'm trying to manage the risk, which goes beyond the financial risk, because this may lead to now we have this concept called environmental litigation. That if my activities are going to hurt communities or environment at a level beyond which is allowed, the communities may bring a court claim against me as an environmental or climate litigation. So these are the the legal and initiative framework that we're trying to look at and understand what it means for the law and what it means for the law and practice. Therefore, we came up with these two research objectives, which tries to understand this regulatory framework. And this is the primary. The secondary is we try to understand what it means for the contractual relationship among stakeholders. So asset holders and investment advisors, fund managers. So their relationship is based on, as I said, on fiduciary duty. Now, this since the nature of the fiduciary duty is changing because someone trusting on the basis of the fiduciary relationship, now I need to look after all the possible risks, including environmental and social and governance. So this is what means in ESG investing. So this is basically what I wanted to say. And if you have any questions, I'll get back to you later on. But in this very moment, please welcome Shukrat Yunusov. He'll talk about legal implications for the Uzbekistan of the green finance. Thank you.
Hey, good afternoon, everyone. I've never relished the prospect to speak after Firdaus. He left one succumbed to despair, overwhelmed by the idea how to keep up the standard and tone, he said. Yeah, but I'll do my best. Speaking of the legal implications of emerging a green finance for Uzbekistan, then probably we have to contextualize. Take the context in Uzbekistan. What's going on? What's the trend now? The trend is corporates, including private and state-owned entities, they are currently actively borrowing funds. And most of the time, they manage to secure funds in international markets. And the question is, on the other end of the line, it's sophisticated investors and sophisticated lenders. They're bound by certain principles, though they're voluntary for now, but some of the research papers suggest, especially those European Leveraged Finance Association, LMA, and other bodies, they suggest that soon sort of ESG factors, as my colleague said, environmental, social, and governance factors need to be taken into consideration while they structuring the deal and throughout the whole investment process. And in fact, is that okay? I mean, I can see the echo. Is it me only? Okay, good. Let me know if I'm too excited and raising my voice and should have, but okay, that's good. And it's there's empirical evidence. We looked with our colleague with those kind of papers and data. There's empirical evidence that green bonds, they're outperforming conventional debt, ordinary debt, which is non-green bond. And most of the jurisdictions, they experience the transition from brown industries to green industries. And probably in the end of my speech, I'll just highlight the commitment of Uzbekistan. But beforehand, just wanted to address a couple of issues. For investors, the concern is now not to simply find the place to invest, but to make sure that investments are made to resilient industries, to resilient assets, which might survive and which might live or may cope with the turbulence and etc. They might be thrown by the environmental changes, social factors, and other governance issues. Moreover, most of the governments, they're committed to international principles for socially responsible investment and etc. And from that perspective, the governments, in order to discharge their obligation, the commitment, they really want to make sure that the companies operating in their jurisdictions or trying to make investment outside, they're really sort of compliant with those principles, and they sort of herald the message throughout the world. And interesting survey conducted by BNP Paribas, and it's conducted a ESG global survey, and it says the top motivation for ESG integration is improved long-term returns. So if as a lender or as an investor, you want to invest your money, for example, by purchasing bonds, we call investors, right? And the main driving factor is, okay, is that okay, it's a fact that they will get the return, but is that the long-term sustainable return? And brand and reputation in the first place. for example, there's a practice of global arrangers, mandate lead arrangers. They keen, for example, some of you may ask question, well, why are they really keen into taking that role? Most of the time for reputation and etc. The same principle works here. So green investors, sort of they want to make sure their capital invested in the green sector and industry, so that their brand and reputation will be increased, saying that they are socially, environmentally cautious and etc. And decreased investment risk, because how investment may sort of represent the risk. Decreased investment risk suggests that because of the commitment of the government, that we suggested that now governments want to incorporate into the legislation the mandatory compliance with the environmental, social, and governance issues. And if you fail to comply, then you are at risk, reputational, regulatory risk, and some other risks. So therefore, people come up with those issues. Nowadays, green bonds and green loans are becoming popular. Definition, he gave me the honor to define, but unfortunately there's no statutory definition, and let me disappoint you. But however, there's International Capital Markets Associations and Loan Markets Association basically provided the voluntary guidelines and 4 components, core components that the needs to be taken into consideration. I know the time is, I think, a bit up, but I'll just resume. Among the 4 components, use of proceeds. In fact, what's the difference of the ordinary finance compared to green finance? It's just different, as my colleague said, it's asset. What's the underlying asset? Okay, are you financing the development of the manufacturing plant that pollutes the environment, or you sort of investing or financing the asset which basically promotes the green well-being of the people and etc. So use of asset proceeds should be indicated in the prospectus special section. And another component is a process of project evaluation and selection. So money is there. So we're about to get the money. But what is the project? How we select? What are the criteria to select the green projects and etc. And management of proceeds. There should be sub-account that money will come in to that account, and then there should be, it raises the questions for Uzbekistan like escrow account and etc., which I believe it's being developed in the new draft of the civil code, but should be addressed soon. But law as it stands now, it would be quite challenging to ensure there will be separate autonomous account that would have immunity from other potential claim from state and etc. And of course, reporting. So you got money, be ready to make the information available on the spot whenever it's raised, because none of the investors, because financial industry is quite tricky. It's all based on trust. You lose the trust, that's it, the collapse of financial industry. So therefore, in order to maintain those trusts and etc., those ICMA principles and LMA green loan principles, they try to make that reporting and monitoring, certification, verification institutions to make sure that parties take into consideration those principles. And suggestions for the government for Uzbekistan implication would be, for example, now CMDA, which is I call architecture of capital markets of Uzbekistan, is actively now trying to champion and lead the process. So I would suggest them to think about it, to introduce the new component called green finance component for the Tashkent Stock Exchange. Just LSE, London Stock Exchange, introduced recently, Luxembourg, Euronext, on all of their platforms, Dublin and etc. They introduced the green finance or Euronext green and etc. platform. It helps to consolidate the data, and it will give the picture in a jurisdiction to what extent the finance are used for green financing, right? To what extent green financing being actively drawn. And of course, a final remark as to what Uzbekistan is doing in this regard to develop the green finance. I'll tell you more. Uzbekistan is not focused for green finance specifically. It has a broader look. Strategy been adopted by the president, Uzbekistan in 2019, 4th October. It's a strategy for transition to green economy, including some of the components. Of course, you cannot imagine the green economy being developed without financial mechanisms. And most of the time, the strategy envisages the introduction of green loan systems, venture capital financing, and envisages the setup of green funds and promoting the green finance in private sectors and stimulating of commercial banks for green loans. And importantly, I think this is one of the motivating factors for our people, Uzbek companies, is the state support of green economy, sustainable growth through fiscal policy. So in other words, give me incentive, give me fiscal motivation. I'm happy to draw more green bonds and etc. So apologies that here I'm finishing. Apologies that I'm doing this presentation sitting because I follow the principle, go green, think before print. So I set my computers here. So thank you very much, everybody.
Thank you for that very interesting presentation. Our next speaker is Mr. Islambek Rustambekov. He is the Deputy Rector on Academic Affairs of Tashkent State University of Law. He has also headed various departments at various institutions in Uzbekistan, and he has a lot of international research experience, and he has also represented Uzbekistan at Untittled. The title of his paper is Recent and Further Developments in Investment Treaty Bid Regulation and Dispute Resolution Prevention in Uzbekistan.
Assalamu alaikum. Good afternoon, dear colleagues and participants of this event. I'm very glad to be here and to speak on this interesting topic. I will try to give some information based on my experience for you, and let's begin to speak about that. So today we understand that, oh, sorry. Today we understand that Uzbekistan is very attractive for foreign investors, and foreign investors would like to invest to Uzbekistan, and that is provided with many factors. But also there's a lot of factors which, for which investors wouldn't like to invest, and sometimes they had such opinion because of our lawyers and law companies. So I hope that my colleagues from law companies wouldn't be offended at me with my such opinions, but this is my experience, my own experience. So in this regard, there is a big role of law companies and lawyers who give their consultations to the foreign investors, because often they want to write an investment agreement for them, and they say that you have a risks by the investing to Uzbekistan, so you need to sign an investment agreement, and also you need to be very clear in the wording of the agreement, and we will help you to do that because there is a lot of situations, etc., which could bring you some issues in future during your business, during your investment activities in Uzbekistan. So this is the situation, but this is one of the bad situations because this brings an opinion to the foreign investor that in Uzbekistan there is a lot of risks. Maybe our lawyers, they don't understand that they make some damage with such speaking and understanding with such consulting of the foreign investors, but maybe they understand but would like to earn more money by preparing such agreements. So everything could be. Let's talk about the investment treaty regulation based on the Uzbekistan experience and regulations. So the last recent improvements or developments in this sphere was the adoption of the new law and adoption of the resolution of the Cabinet of Ministers of August 2nd. And first of all, I think there was one presentation that in the investment treaty regulation, according to the Uzbekistan rules, there is two types of regulation. This is the investment agreements and bilateral investment treaties. And according to the legislation, the investment agreements are concluded between the investors and the government, and as a rule contains additional guarantees. And bilateral investment treaties, so you know that is concluded between the two countries, this is the intergovernmental treaties, according to the law of the Republic of Uzbekistan on international treaties. And the recent regulation was the adoption of the resolution with the new amendments. This is the resolution of the Cabinet of Ministers dated August 2nd, 2005, number 180. And this regulation on the procedure for notification of the application of guarantees established by Article 19 of the new law on investment and investment activities. And there was a model investment agreement between the investor and government of Uzbekistan, which was attached as an annex to this resolution. And that is really very good regulation and positive result, which provides like more opportunity to the government, to the state bodies during their negotiations with the investor, and they can use this model investment agreement during the negotiation and use this like text, this wording during the conclusion of the investment agreement. And this is also, I think, not very good for the law companies because they already have a model agreement which they can use, like foreign investor can use this model agreement, and they could maybe not need to have the consultant from Uzbekistan law company. But in my opinion, I am the person who thinks that that such investment agreements shouldn't be concluded, and they could be concluded only in very necessary individual cases when the investment is very huge, when it gives a lot of opportunity to Uzbekistan. Because at time in practice, there's a lot of investment agreements which are concluded in many cases, in many amounts of investment, and which not always, in my opinion, good for Uzbekistan, because always the investor tries to include additional guarantees, additional like issues which they can use during their business in Uzbekistan, and this practice is not very good practice in my opinion. And because why I'm telling that? Because the laws and law enforcement practice of the country should clearly show the investor that all laws work accordingly as they are written in the paper. And there is no difference between the law and law enforcement practice. All guarantees provided by law are fully respected and not violated. In one word, the rule of law are totally guaranteed and the country has a stable economy and legislation. So this is the main thing when the investor are investing to any country, because I have talked with a lot of investors and they always tell, they say, so you are talking about maybe English law or some other laws which can be used, but they tell, so it doesn't differ. So it doesn't matter which law you will use. So you can use some African law maybe, or some else. But the main thing that this law should work as it is written in the paper. This is the main idea. So, but their opinion that such laws doesn't work accordingly in our country, and because of that, they are requiring the signing of the investment agreements. Just remember that I mentioned in the beginning about the guarantees and the law companies' work, maybe. So lawyers, during their negotiations with the foreign investors, they warn investors on possible risks and always tell them to conclude investment agreement, as I mentioned. But they want to include to these agreements all possible and impossible guarantees which could be given by the government or which couldn't be given by the government or provided by the government. They do that because they will prepare this agreement and earn good money for that. And they don't understand sometimes the situation that the laws of Uzbekistan already regulated these guarantees. And there is also regulations that some part of the guarantees couldn't be given. In such regard, they try to include to the agreements such guarantees like the guarantee on expropriation, exchange of currency, change of law, tax and custom incentives, and all of these is already regulated, as I mentioned, in the laws of Uzbekistan. But some lawyers tell to investors that they need to include this, and this is very necessary. They even tell them so that will help them if the situation in the country will change, if there occur again the problems with the currency exchange, and there could be something, the change of the law in future, and that could bring an issues for them. So this brings a bad opinion about the Uzbekistan economy and investment climate in this investor, and this investor begins to ask to give them these guarantees, even when you tell them, so this is regulated already by the law on investment and investment activity, by tax code, by other codes, etc., etc. So they say, no, we want this guarantee because our councils tell us that the situation could be changed sometime. And you can remember that 3 years ago or 4 years ago, there was a problem with currency exchange, but everyone should understand there is no way back. So it couldn't be changed. I think so. Yeah. And also we need to understand that already these situations are, sorry, are already regulated by the, this is not mine, this is, sorry. So this is already regulated by the bilateral investment treaties of Uzbekistan with other countries. So now we came to these bilateral investment treaties. Because bilateral investment treaties already gives to the foreign investors some guarantees on the change of law, and if the situation will occur and they will lose their investments, they can go to international arbitration or use some other guarantees which they have in the bilateral investment treaty. So this is already regulated in bilateral investment treaty. So you can see the meanings of the bilateral investment treaties, and by signing of the bilateral investment treaty, the host country commits itself to fair and equitable treatment of foreign investors. And in this regard, there is no need for the investment agreement between the investor and the government. But the practice is not as it should be. Let's talk about the background of BITs. So this is the first BITs. Yes, please. So you can see that the first BITs were signed by Uzbekistan in early 1990s. It is 1992, and at the time there is more than 50 BITs. So we can see that there's already 55, as I remember, the BITs. And thank you. And at the time, Uzbekistan developed its draft model BIT based on ISDS experience and best practices. So you can see the main Uzbekistan investment treaties, and also Uzbekistan is a part of the Energy Charter Treaty. And I would like to speak a little about the model BIT, which are drafting by the Ministry of Justice of the Republic of Uzbekistan. It was prepared in 2019, and at time it is under the discussion around the state bodies which are responsible for that. And this is maybe the further development on the investment treaty regulation in Uzbekistan. Because if we will make a research on the bilateral investment treaties, if you will take this 55 bilateral investment treaty, the wording is really very bad, because nobody used to analyze and practice in sphere of bilateral investment treaty. And there is already many stages of the improvement of bilateral investment treaty, and it is never analyzed in Uzbekistan. That's really very bad. And that was made first in 2019 by the Ministry of Justice and prepared the draft model BIT. So you can see the main key documents in the screen, which were the base for the model BIT of Uzbekistan, which is used for that. And also during the preparation of the model bilateral investment treaty, Uzbekistan's team also analyzed a huge amount of cases, of the investment cases of Uzbekistan practice in that, and also the model BITs of foreign countries, and drafted the BIT. And let's talk about the maybe main aspects of this draft bilateral investment treaty. First of all, the main goals of that was to promote and facilitate long-term sustainable foreign investments. This is, I think, the main idea, to provide sustainable foreign investments, and to provide foreign investors with protection from expropriation and nationalization, as well as establishing minimal and national standards of treatment, to eradicate corruption and bribery in the process of establishing and maintaining investments, to uphold main principles of human rights, labor legislation, and environmental protection. The main, I think, new thing in this draft BIT, that was the definitions that asset-based and enterprise-based approaches. So in the draft, we used mainly the enterprise-based approach for that. And I will try to share this presentation, because if we will talk about that, that will take a lot of time, and I think I wouldn't be able to over my presentation. And the second one, the anti-corruption provision. So we have a lot of experience with the corruption provision, which when we use this during our investment cases in ICSID, in ad hoc and other arbitrations, also in ICC. And the human rights also issues are very popular at time, which we need to include to the document. And the new thing is also the institutional governance, which we included to the draft, and that means the establishing of the joint committee to resolve the investment cases. And the last thing, dispute prevention and resolution. So the dispute prevention was the consultations and negotiations through joint committee, which I meant, and the second one, the direct negotiations, then the mediation procedure, then exhaustion of local remedies, which are also included in a new law on investment and investment activities. And the last one is arbitration. So we think that these mechanisms reflected in the laws and in the BITs will help Uzbekistan to protect its economy from maybe claims which could occur, and will help not only for resolve the dispute, but to prevent against these claims on the investment cases. So thank you for your attention. That was my brief presentation for you. Thank you. Oh, the question, please.
We'll do that at the end. I know that this was a very provocative presentation, so I'm sure we'll have a lot of questions.
I will sit and answer. Yes, the plan is, if you will see, there is already the roadmap of the Cabinet of Ministers from 2018, and there is regulation or instruction to the Ministry of Foreign Affairs, to the Ministry of Investment and Foreign Trade, and Ministry of Justice to begin the negotiations with these countries and to reconclude these bilateral investment agreements. And so that began even from 2016, as I remember, and that was the bilateral investment agreement with Turkey. If you can see this one, the first one was in 1992, and this agreement is really very bad, this bilateral investment treaty, and we have a lot of cases with Turkish investors, and there was always a lot of issues with our bilateral investment treaty. And one another thing, also, if you will take all the bilateral investment treaties, you can't see the regulation of the timing of the submitting the claim to international arbitration. But in the newest BITs of the world, you can find always the regulation of the 5 years limitation or 3 years limitation. But at time we have a case which occurred in 2005, and they submitted their claim in 2017. This is also an issue. This is also a Turkish case. No, in that period wasn't Uzbek model. So that was the model of Turkey. Their model BIT, they adopted it in 2009. So we signed in 2016 with Turkey a new BIT based on their model BIT.
Okay, sure.
Okay, thank you. First of all, thank you very much, Islam Beyke. So my question is, what would be attitude or reaction of that countries with which we want to reconclude our investment agreements? And do we have enough bargaining power as well to do that?
Thank you for your question. This is really a very interesting question because this is an issue. We understand that, but all these BITs, they are concluded to 10 or 15 or 20 years. So after that, we need to reconclude a new BIT or make this BIT, like prolong this BIT. But I think it wouldn't be a very big issue because other countries, they also understand that these BITs are really very old and the wording is really very bad, and the new BIT will also serve not only to Uzbekistan but to this country too. So if our investors will invest to this country, they will be also more protected. So we have analyzed, and there are included such regulations about the environmental protection. So there was a case with, as I remember, Ecuador, and they counterclaimed to investor on the environmental issue, and they won $40 million in that case. They lost this case, yes, for 300 million, but they won 400, so they paid 260. But this is also a good thing. So I think other countries will be also interested to sign, but there is an issue with such countries like US. It is, I think, negotiating for 10 years, and they can't sign a BIT with US, as I remember. Thank you.
Okay. Thank you very much. Our next presenter is Musa Reserve. Musa has done his LLM in comparative law and politics from Nagoya Graduate School of Law, Japan. He's also doing his PhD over there. He specializes in international investment law and arbitration. He is also a lecturer at WIUT, and he teaches Introduction to Law, as many of you would know. And he's also a participant of the IAA Mapping Project, a collaborative initiative between UNCTAD and universities worldwide to map the content of IIAs. Mr. John?
Okay. Good afternoon, dear colleagues, distinguished guests, friends, students. It's great pleasure to present my empirical study, which I've started in 2017 as part of my PhD thesis. So I'm looking forward for your comments. I think that will be helpful for further shaping my thesis. So basically, this study analyzes Uzbekistan's investment promotion efforts over the last 30 years, I would say. And also, it provides some empirical findings on problems, challenges the foreign investors are facing in implementation of this investment promotion policies. So due to time constraints, I'll be very brief. So let me start. So here's the outline of my today's presentation. So I'll start with a bit of theory, if you don't mind. Then I'll provide my empirical findings, research objectives, and some case studies which I used for some recommendations in Uzbekistan or for Uzbekistan. So a bit of, again, about theory. So it's not a secret that the role of foreign direct investment, or FDI, is essential in the development of economy of every country. And it contributes through a transfer of technology, financial resources, and even innovative management techniques. And there are several surveys which showed the developing countries that have or that managed to attract foreign direct investment consistently develop their economies. And therefore, it has become one of the priority issues for every country to attract FDI. And you may have a question, what's or how the FDI is usually attracted, or what countries or what kind of measures they take. So in competition for FDI, countries or governments have been engaged in marketing their country through so-called FDI promotion activities or policies, which include basically signing international investment treaties, which includes both multilateral treaties and bilateral investment treaties. And also developing domestic foreign direct investment legal framework, which is another important part of FDI promotion activities. Okay, and lastly, guarantees and special incentives provided to foreign investors. And Uzbekistan also is not an exception. So since Uzbekistan achieved its independence, it has been always priority issue for Uzbekistan to attract foreign direct investment. So as my colleagues already mentioned partially, so Uzbekistan is party to more than 50 investment treaties and 55 double taxation agreements. And apart from that, since independence, Uzbekistan has been developing its domestic FDI legal framework. And you can see here a list of regulations which are intended to form the FDI legal framework of Uzbekistan. And also, Uzbekistan provided several tax incentives, free trade, industrial and economic zones in different parts of our country. Besides that, over the last 5 years, registration procedures for new businesses have been simplified through a center of government services, based on one window system and online registration through online registration practices. Okay. Fine. Okay, so another things which has been done is enhancement in visa procedures and permits for foreign citizens, investors, and also Ministry of Investment and Foreign Trade took a role of investment promotion agency in Uzbekistan through providing investors with consulting services on establishing their businesses, registration, and of course, legal assistance. And finally, I think it was in 2019, Council of Foreign Investors has been established, a body which consists of experts from international organizations, international companies, foreign investors in Uzbekistan, which basically consult government of Uzbekistan on improving investment climate. But the question arises whether this brilliant policies or very comprehensive legal framework is implemented effectively in practice or not. So for that reason, I pursued some empirical study. So I conducted interview with government officials, international lawyers, and of course with foreign investors. So to analyze whether the implementation of current FDI legal framework is really effective in practice or not. So also this interview was helpful to collect some of their recommendations to improve the investment climate in Uzbekistan. So now let me present you some findings, also interview findings. So most of the investors, I would say, face problems in applying and utilizing these guarantees and incentives provided by investment promotion policies. So one of the reasons is a lack of efficiency, capacity, and accountability within the public sector. Okay, so there are sometimes bureaucratic red tape and unexpected delays in public service delivery, especially in local agencies. And also there is arbitrary inspections by some government agencies such as tax committee and etc. And based on the statistics, well, that's for the both local and foreign investors. At least one entrepreneur out of 50 face this so-called arbitrary inspections by some government agencies. And also there is an inconsistent compliance with contract commitments of government agencies and some state-owned enterprises. The second issue is due to ineffective dispute resolution. So foreign investors tend to avoid exhaustion of local remedies due to some impartiality of local courts. So sometimes, they are biased in favor of government agencies or government-owned companies. And this has been present in especially local courts. Okay. And one of the when I talked to one of the investors, it was a Chinese investor in I think Nikus region. They spent 2 years for invalidating arbitrary decision of local authorities, and it has been achieved through the intervention of some government officials from executive branch. So and also there is some jurisdictional limitations concerning ADR tools, and also there are some weaknesses in enforcement mechanism of these ADR tools. Okay. So to sum up my empirical analysis, I would say Uzbekistan has heavily focused on FDI promotion policy. So by signing investment treaties, developing very comprehensive and modern legal framework, which contains guarantees and several incentives to foreign investors, but there is still a gap in implementation of that FDI promotion policies, okay, which really hinders expected outcomes. So I set a research question: how FDI promotion efforts of Uzbekistan can be effectively implemented in practice. And I come up with so-called FDI facilitation policies. So Uzbekistan can fill the implementation gap in its FDI promotion efforts through adopting FDI facilitation policies. At the first look, these two concepts, FDI promotion and facilitation, looks similar or interchangeably used, but if we look closer, there are some differences. So for the sake of clarity, I provided some definition. So if FDI promotion is all about showing or creating a legal framework to regulate foreign direct investment, facilitation is all about policies and actions aimed at putting them into practice or implementing these laws and policies in real life. And another question may arise: what kind of FDI facilitation policies should Uzbekistan adopt in order to create more favorable investment climate? So I chose Global Action Menu for Investment Facilitation, which has been initiated or started in 2016 by UNCTAD, which collected best practices which has been achieved through the legal assistance projects of UNITAD in different developing countries. So it's basically a guideline for policymakers and government agencies to adopt domestic and international FDI facilitation policies. So the action menu proposed 10 action lines with series of options. So it includes actions that countries can choose and implement unilaterally, and options then can guide international collaboration. And finally, it contains specific actions for investment facilitation policies for developing or low-income countries. So significance of this action menu is first of all, it aims at improving investment facilitation through domestic policy reform and strengthening rule of law and capacity building. Sorry, due to time constraints, I need to move to the main point of my presentation. Sorry about that. So the one thing why I find this particular action menu suitable for Uzbekistan, because it doesn't recommend significant reforms or changes in the legal framework, but it actually aims at filling and complementing existing legal framework. So it contains some principles of good governance, such as predictability, accountability, participation, and transparency. And I took some recommendations for Uzbekistan. So first one is creating client service charters for government agencies, which will contain a clear performance standards of services. So here's an example of client service charter. I mean, some part of it, of Malaysian Investment Development Authority. And second recommendation is creating or extending authority and functions of business ombudsman in Uzbekistan by using Korean practice. I think I will stop here. So thank you very much, and I'll be happy to take your questions.
Thank you, Musa Jan, for that very informative seminar presentation about practical issues related to foreign direct investments in Uzbekistan. Our next speaker will be joining us online from India. Should I wait for him?
You can call him if he's
So Anshuman, I hope that you are here and you're able to hear us and you're able to participate. Okay, so I see him. And I also hope that I'm pronouncing your name correctly. Okay, so just a moment.
Hi, yes.
Yes.
Good
Hello.
afternoon.
Good afternoon. So Anshuman, I hope, again, I'm pronouncing your name correctly, and I will give a brief introduction to you, and then I will hand over the mic. So we have Mr. Anshuman Hazarika from the Indian Institute of Management, and his paper is titled The Singapore Convention, A Missed Opportunity for Central Asia. Just a brief introduction to who he is. He's done his Doctor of Laws from Saarland University in Germany. He's done his LLM in Foreign Trade and Investment and International Dispute Resolution from Europa Institute at Saarland University. And he's also done his BA LLB from Punjab in India. He has won several awards for his research. And without much further ado, please welcome Mr. Anshuman Hazarika.
Yes, thank you, Ms. Karimi. If I am audible and clearly visible to everyone, thank you, the Westminster International University in Tashkent, for providing me the opportunity, and thank you, organizers, for inviting me here. And also thank you to my ex-colleague, Ms. Nilufar Abdullatova, who informed me about the opportunity here at the Westminster International University. I have never been to Uzbekistan. I have passed through the Tashkent airport. I have been to your neighbors, but never had the chance to visit it. But I like Uzbek pulao and would like to visit it someday. So going beyond going beyond the basics, I have been listening carefully to the discussions which have been happening in today in the presentations being made by the different scholars here, and I am amazed by the discussions which are happening on a very relevant and pertinent topic as to how we can promote investments in Central Asia and how dispute resolution methods are a key part of the entire process. Now, I tried to slightly move away from going beyond dispute resolution in a conflicting manner, let's say arbitration or judicial dispute resolution, to something more mild, which is mediation. Now, mediation is something which has not received the spotlight that it should, and there are certain reasons for that. People generally trust the third party, to a neutral third party, to be able to come to a mutually acceptable solution, but what happens is that we do not recognize the fact that sometimes even talking can help, and talking through a party who knows about the issue and who can help you to come to a solution can also help. And that's why I look at the Singapore Convention. So well, the Singapore Convention is the next in the generation of international treaties which aim to facilitate international dispute resolution in a manner by providing that, let's say, awards, judgments, or in case of the Singapore Convention, settlement agreements have international recognition. Now, what was revolutionary about the Singapore Convention was that it is for the first time that we have the international mediated settlement agreements, or IMSAs as we call them. We have them for global enforceability. Now, when we talk about global enforceability, the primary example which comes to our mind is the New York Convention. So when we think about the New York Convention, we see how it revolutionized international arbitration. Parties around the world are confident to engage in international arbitration, and they're happy to engage in international arbitration because they're sure that the awards that they will obtain can be enforced across the world, Now, mediation and to a large extent civil court judgments did not have this recognition. So to plug this loophole, what the UNCITRAL decided is that they decided to come up with a convention called the Singapore Convention. And this convention till date has 53 signatories and 6 parties till date, and it has already come into force. Now, a unique factor about Central Asia in this regard, and the fact of the Singapore Convention, is that none of the Central Asian countries except Kazakhstan is a signatory to the convention. So this brought me to the point where I wanted to discuss as whether Central Asia is missing a good opportunity to establish itself as a place which recognizes international dispute resolution, and could this be an alternative to methods such as arbitration, which are now frequently considered as something which is against state policy, as something which is not in the interest of the state. Okay, so moving forward, I will try to maintain my time. So what do we mean when we talk about mediation? What do it mean when we talk about mediation? So when we take the definition from the convention, it says a process irrespective the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of the dispute with the assistance of a third person or persons, and they use a mediator. Now, the primary factor which differentiates mediation from basic negotiation is that we have a third party, and this third party, which can be a person or more than one person, they basically help the parties to come to a settlement. They basically help to push the discussions forward. And what do we have when a mediation ends? When a mediation ends, we have something which is called a settlement agreement. Now, settlement agreements are a very sticky subject. Why are settlement agreements a sticky subject? Because countries want to control how settlement agreements are formed. And they want to control it because settlement agreements contain a variety of issues. They include reference to the domestic laws. They include how much money has to be paid. They include what will happen in the future. And most importantly, they also include provisions of what will happen if the settlement agreement is not enforced. So countries regulate settlement agreements very strongly. And in many cases, even if they permit settlement agreements, they want you to take the settlement agreements to the court, and then the court should look at the settlement agreement and then allow it to go through, and they generally pass through it as a judgment of the court. So the Singapore Convention basically tries to touch upon the issue and tries to harmonize how the settlement agreements come into play. And they have tried to limit the Singapore Convention to only disputes of a commercial nature. Now, the term commercial nature, which is used in the Singapore Convention, is not defined there, but it is defined in a model law which comes along with the convention. So it was released approximately at the same time as the convention. And when they say disputes of a commercial nature, they include disputes of all sorts which are related to a business. Now, let's see why they have limited it to disputes only of a commercial nature. Now, I've done this because sometimes settlement agreements may also contain civil law issues. So issues relating to marriage, issues relating to adoption of children, issues relating to distribution of property. Now, these are not purely commercial issues, and there are a lot of domestic law and personal law factors which are involved there. So the Singapore Convention tries to walk away from that and tries to limit it to commercial issues only. Okay. Moving ahead, the Singapore Convention also limits itself to international disputes. Now, when they say international disputes, it means that the two parties to the settlement agreement and ultimately the mediation, they have to have their places of business at different places, and the primary factor is that they must not be from the same state. So they must not be based in the same state. Now, why is this important, and why have I brought this topic to this particular conference? The basic factor here is that when we are talking about investment promotion, and when we are talking about investment facilitation and investment dispute resolution, what we have is a foreign investor, and what we have on the other side is another aggrieved party in let's say Uzbekistan or another Central Asian country, or the Uzbekistan government or a government agency, or a Central Asian government or government agency. And this is the ideal place when a convention like this can come into play. Why? Because there are two parties from two different countries, and both of them are interested to settle the dispute in an amicable manner. This brings me to the factor of investment dispute resolution. Now, as many of our speakers who have already spoken before would agree, and our audience would also see when they go through the facts, a lot of these investment disputes end in settlement. And the entire arbitration process just ends up as a money spinning exercise for the lawyers. So why not have an opportunity to enter into settlement agreements per se, which can be enforced? So this is a mode to promote these settlement agreements, which ultimately many of these disputes ultimately will have settlement agreements, and they will go into settlement, and there should be a method to enforce these settlement agreements. Now, moving ahead, when I talk about Central Asian countries, I take the World Bank classification and I say Kazakhstan, Uzbekistan, Kyrgyzstan, Tajikistan, and Turkmenistan. So let's look at the picture of what is happening in mediation in all these countries. So now before we go on to the country specific picture per se, let's look at how Singapore Convention has changed the picture. First, much like the New York Convention, it now allows you to have a global enforcement of settlement agreements. So no matter wherever you have entered into the settlement agreement, you can go and enforce it into any of the countries which are parties to the Singapore Convention. As of now, we are just beginning off. We are just 3 years into the convention. So we have 6 states where you can go and enforce the settlement agreements, but this is likely to increase in the future, and all major economies are a part of the Singapore Convention. The next is that there are predetermined grounds for refusal to grant relief. Now, this is a similar feature like the New York Convention, where the grounds under which a court may say that we will not allow this settlement agreement are fixed. So this means that there is very limited possibility for the courts basically to evaluate any other grounds beyond that. So parties cannot basically dilly-dally on the enforcement of the settlement agreement. Next, the governmental agencies or governments may decide not to be covered under the convention. Now, this is also something very important. Why? Because sometimes what happens is that governments want to be protected from liabilities. And then in that case, what they might say that let's exclude this particular situation from the Singapore Convention, and you will have to enforce it by our mutually agreed methods. This is also possible. And lastly, there's a possibility for participation by the states even as regional economic integration organizations. So let's say the European Union wants to join the Singapore Convention, it can do so. Now, in Central Asia, what has happened? So in Central Asia, the countries of Central Asia are in different stages of adoption of mediation. So we have 3 countries which have adopted mediation as a part of domestic laws, but Tajikistan and Turkmenistan do not yet have laws covering mediation. And in terms of the Singapore Convention, Kazakhstan is the only signatory to the Singapore Convention. Now, whatever happens in the future, what needs to happen is that in case the countries want to enter into the Singapore Convention and want to ratify it, there's a need to create harmonization of mediation laws. So because the mediation frameworks which have been built in Central Asia are pre-Singapore Convention and do not basically reflect the current ground situation and globally accepted practices. So for Uzbekistan, it has an advantage. It already has a mediation law which was enacted in 2018. And then the business activities which are covered under that mediation law, they also fall under commercial activities discussion of the Singapore Convention. So definitely Uzbekistan is one step ahead here. And then it even considered to join the Singapore Convention. I did not know why it did not finally sign the Singapore Convention, but yes, it did consider to join the Singapore Convention. And as of now, based on the existing Uzbekistan mediation law, the settlement agreements which are formed under Uzbekistan mediation law, they can be a part of the Singapore Convention enforcement process if Uzbekistan joins as a party to the Singapore Convention. For Kyrgyzstan, of course, it also has a law on mediation enacted in 2017. It also looks to be compatible prima facie. We need to go into the details of the law to understand if they can directly ratify the convention. But yes, they also look to have a good system in place already. Kazakhstan also has a mediation law since 2011, and then it has a head start here, and they are also a signatory to the Singapore Convention. Now, the problem in all of these countries is there is a process within the laws that many of the settlement agreements have to go to the court and then be taken forward as judicial decisions. Now, judicial decisions cannot be enforced under the Singapore Convention. So this is a potential hurdle which can be corrected in the future by moving forward through the model law. Now let's talk a little bit about the model law. So the model law came along with the Singapore Convention, and this model law was built with 2 aims in mind. First, for countries which do not have a law on mediation per se, directly implementing the model law into the domestic legal framework would mean that you are ready to ratify the Singapore Convention. Now, this is similar to the UNCITRAL model law, which came into force for arbitration. So similar to the UNCITRAL model law, which made a country ready to accept New York Convention procedures, the UNCITRAL model law on mediation, which came into force in 2018, also makes a country ready to ratify the Singapore Convention. Now, among the advantages, I have already told them before. One thing that I would like to focus on is that mediation does not receive the spotlight in international investment dispute resolution. And I believe that promotion of mediation, if it is included, and we are talking on the draft Uzbekistan model BIT, if it is included in the draft Uzbekistan model BIT, it can also be a potential mode of dispute resolution. It can be a potential mode of dispute resolution. And then what we have is the Belt and Road projects also coming up in Central Asian countries, where instead of arbitration or domestic judicial processes, we can also look at mediation because it's cheap, it is effective, and it helps in rapid resolution of the disputes. So that's it from my end. I will submit a detailed paper in the future to the conference. Thank you everyone at WIUT and at CLF for providing me the opportunity, and have a great evening. Thank you.
Thank you so much for that very interesting paper. I hope you're able to join us in person in the future. Our next presenter is joining us from Canada, I believe, Mr. Rinat Ziadilayev. I hope that you can hear us, Rinat.
Yes, I can hear you. Can you hear me?
Yes, I can hear you, yes. So just giving you a brief biography of Mr. Ziadilayev. He is working at Astound Commerce Canada, and he has more than 8 years of combined law firm and in-house experience in international legal services in the areas of commercial arbitration, commercial contracts, commercial law, data privacy regulations, and intellectual property. His recent experience is in leading legal projects for an e-commerce web developing services company while maintaining strong relationships with international and external stakeholders. While working in Astound Commerce Canada as corporate counsel, Mr. Ziadilayev serves as a legal support to global organizations. And prior to joining Astound in August 2018, he worked as off counsel for Rights and Able law firm from January 2018 to July 2018 in San Francisco. He's also worked as a research assistant for a research center in Oslo, and he's worked in St. Petersburg at a law firm over there and has experience working in Tashkent as well. He holds a Master of Laws from the University of San Francisco School of Law. And he also holds a LLM in business law from St. Petersburg State University School of Law in Russia. And the title of his paper is Investment Promotion and Protection Through State Policy Making. What are the options for developing countries beyond bits and myths? So, Rinat, the ball is in your court.
Ms. Karimi, hi, and to everyone who's participating. I'm really pleased to present today. I was brought into by one of your course leader, Khalida, and I was really happy to present something could be different from from traditional legal, I could say, presentation. It will be a little bit different because it ties to my background of working first in academic sphere and then switching basically day-to-day practical work in US. So I don't know how I'm gonna, am I going to be sharing my screen or?
Yes, we can see your screen.
Can I share?
Yeah.
Okay, let me share presentation. And I was really pleased that our moderator is from the graduate of U of T, if I'm not wrong. Ms. Karimi.
Yes, I am. Yes.
Nice to meet you too. So,
nice meeting a fellow Canadian. I'm assuming you're Canadian and not American.
Yeah, I saw the background. I was really curious yesterday when I was looking through. Thank you so much. So I'll try to, I didn't give the whole content of the presentation to avoid stealing the surprise I'm going to be talking about, but mainly I'll try to a little bit remind us a bit the lessons learned through the government's in investment practice, investment protection and promotion, touch upon slightly on the higher level of the investment arbitration, and finally see other options that governments or nations these days they can look at, and doing that, then at the end we'll try to look at the couple of scorecards, how practically basically the governments and nations can approach in promoting and protecting investment in their countries. And we'll try to do it in a balanced and solution-oriented, more holistic and practical approach, and looking beyond the legal and procedural structure. My whole background actually in investment arbitration comes from very legal, procedural oriented study. I did my master thesis in differences between jurisdiction and admissibility. It's just pure law when you talk to people like normal, ordinary people who don't involve their practice with law. It might be very heavy legal oriented. So, but then I moved to US, and last 3 years I've been involved with the practice in law from practical perspective. And there I could see like a total switch from when you do research in the legal industry, and when you day-to-day heavily, very hectic like practice of law. And I believe US is one of the forefronts of in many ways, and even international or local, their transactional law. So I wanted to basically go away a little bit from traditional and try to connect them and show people how the day-to-day actually work of the investors go, because I'm involved in M&A transactions and attracting investors. So, and when every investor, when they're going and when we're working with them, it usually brings to the point that each investors try to see picture not from what agreement or what BITs or MITs are signed. They usually try to see at okay, what I'm involving myself in going into this project. Exactly the same thing happens when they buy the company here, which is day to day. And my whole like last 3 years was in Silicon Valley, brings it to the point that every investors try to the company from core, like inside out, and then whole due diligence goes. And what I see in international level, it's exactly the same thing. Every investor, when they're going, they ask different departments, not only legal departments, asking like, hey, do we have bilateral investment treaty there? They will ask like, give me everything about this country. And then if the country is not promoting itself from the good side, and just only championing to sign lots of BITs or any other agreements, but they don't develop internal market to meet the requirements of asked by investors, that might be a flaw from one side of the coin. So, but not to be too much going to actual what the policies could be offered. I just wanted to go through briefly, and my other colleagues might already talked and mentioned about these some other parts of international investment law, then signing bilateral investment treaties. And I heard that Angushman talked about the mediation, and I heard about FDI facilitation. But basically, I just wanted to remind us what the international investment law stands on. It's basically tried to, from the beginning, from the first days when it was signed between Germany and Pakistan, the main idea was to protect and promote investment. And no one thought at that time, I mean, that there was considerations, but not heavy considerations about how the governments or local host states rights are going to be protected. And when investor comes, how government can interact and put its rights to protect. So that brought to some sort of frustrations over last decade of many arbitration cases. And especially, you can see here, I'm sharing that BITs, MITs, or investor state agreements, and then arbitration goes exit or non-exit, some ad hoc arbitrations, and this all builds up international investment protection, or we lawyers look at this in international investment law. This all brought to lots of discussions about what is when governments try to say that we have a right to regulate. We can regulate certain areas, and we don't want to be dependent on investors' wish. But investor on other side, they're risking. They're smaller team player. Not all investors are too big that they can absorb big loss, right? So and they say that we have fair and equitable treatment. So all of these brought only around hugely involved in rule-oriented and treaty signed game of like 30, 40 years. And we also, all the other presentations before me was saying, hey, what are the rules here? What is the arbitration or BITs are signed here? And this has brought that no policy oriented or power oriented issues has been discussed. And this has caused, of course, issues even in Europe when we saw the cases with renewable energy cases in Spain and Czech Republic and Italy, which is still going on. And till today, it started in 2011 and is still going on. There are frustrations both from investor sides and there are frustrations from governments because they wanted to regulate, they wanted to incentivize energy sector, but it ended up huge losses to these governments. And I brought the example here from this famous case, Simpra in Argentina. The government also had many expectations in respect of the investment that were not met, were otherwise frustrated. Apart from the question of investment risk, it's alleged that there was expectation that the investors would bear any losses resulting from its activity, work diligently in good faith, not claim extraordinary earnings exceeding by far and reasonable terms, resort to local courts for dispute settlement, dutifully observe the contract commitments. So this is usually neglected and investors don't work that way, and it becomes frustrations from both sides. I brought examples here, but there are huge resources put by the governments. There are huge resources put by international organizations, and everyone is talking about reforming investor-state dispute settlement, also under Untitral, and then reforms under WTO, which is very promising. It's not reforming, the second one is not reforming, but basically more facilitation, understanding both sides and helping from practical standpoint. And my next slide actually brings us to the main point of this whole presentation. So if the governments are understanding and seeing the problem from all of the, and doing the comprehensive approach, they would not only stick to signing agreements, but develop very good, very comprehensive, I would say, and robust system and policy making in their internal market in order to attract investors. And I can say that working in the company as in-house counsel, our day-to-day work is how we're gonna attract more investment, and that is on the ground by each investor. It's exactly the same thing for the government, because if the government thinks as, okay, how am I going to attract more investment, they have to be very proactive. I listed here from UNCTAD, who does investment policy review. I think this is a very good tool for any developing country to do this reassessment. We have also private agencies like a Deloitte or like other banking institutions who do this for governments. they take apart everything in your policy making and they give you very good suggestions. And you can see even here, Uzbekistan did it in 1999, but they haven't done it as many other nations who did it second time, because the time is changing and UNCTAD's proficiency is changing, and they're being very, very helpful recently. The outcome from these policy reviews is actually twofold. Is their investment is rising to 50% over like 3 or 5 years. That's why I believe this helps in for reassessment. But what they need to do, and I tried to analyze and put a list here for the countries, what they can do. Some of them have been mentioned, some of them have been discussed, but I still wanted to bring it back and talk about some of them, which I believe is very, very important, and putting it as an agenda to each of them, each nation who would like to attract the investment. And first one you can see is building very strong investment promotion agencies. In my paper, I mentioned about Brazil, but also here in the presentation, I put examples of top 10. Here is not top 10, but basically in the investment promotion agency list gathered, there are many of them which is very famous in the world, even like Dubai, who's not mentioned here, super famous. In 2019, these 7 were in the top. Singapore and Malaysia, twice mentioned, Hong Kong's, Germany and Portugal, and in the second, like Berlin, partnered from Germany, also very famous institutions. These agencies work very, very hard today, and they are making super job in promoting their country. Some of them work separately from the government in order not to affect a government involvement. Sometimes they're supported by government, sometimes they're partially owned, but in any event, they're doing a great job. And I wanted to mention here why I also picked Brazil, because Brazil only has 2 BITs in force. And I guess the people who do research in international investment law, they can clearly see that Brazil is one of the phenomenon who didn't sign so many BITs, but still they're top 7 who brings investment, one of the developing countries on top 7 who bring investment in their country. So it's not always the case that you have a good list of agreements where investors can rely on. They also look at the overall picture in the government, in the country when they're coming in. And next policy or important thing is developing investment aftercare framework. Very good examples here I brought at Northeast England and Czech Invest. They developed supply chain, very robust supply chain assistance to the investors who came into the country. So they basically put more than 20 networking events where they call suppliers from all different countries, and they help investors who are already came into the country and making contributing to the development of that nation. And you have to know that for each dollar which is invested, it comes as foreign investor. Another dollar in investment comes from inside. And also for one job created, it's UNCTAD's statistics, created by foreign investor, there's going to be one plus one more job created internally. So it goes both ways. So we need to, every nation, I believe, have to work on these agendas. And then without tracking and evaluation, which is done by every investor when they report to their board quarterly, I believe every nation has to track and evaluate where it's going and how things are going. When they did reassessment, there's a live metrics provided by UNCTAD that can be used. They're very helpful, and they list important things what actually investors look into. So that could be very helpful. And dispute mitigation, I try to avoid again about arbitral dispute resolutions because it's expensive, as Angshman mentioned, and conflict management mechanisms has become since 2015 one of the very hot topics, and you can see they are ending up being in modal BITs. They're ending up being in already signed BITs. So this is very important issue that the governments have to look into, but it cannot be simply created. Of course, their international players have to participate in this and put their assistance. Other key business related policies and regulations, and they're such as foreign exchange control, trade permits. This is more economical, but I would stay a little bit about labor markets and judicial rule of law here. So labor markets, when you're coming in, actually our company is also when they were looking at relocation, we looked at 3 different countries. One of them was Turkey, India, and I suggest that as Uzbekistan. But people, our investors were not too much interested because they said, okay, what does the labor market looks like in Uzbekistan, and what it can present, what it can give, what are the rights of the people who would like to go and work there, or what are the rights of the people who are working on the ground. So all of this also causes problem and discussions for investors because they are part of the other organization or associations where their reputation are very important. And you might see in the news from time to time in different countries, if they have factories, and in the factories they're like exploitation of the and the job market, that becomes a huge problem for any investor. And judiciary and rule of law, I guess everyone understand that has to be brought to some level that investors feel comfortable. Of course, they can rely on arbitration or other mediation or other solutions, but there's always day-to-day resolution of your problem where you just simply resolve small things. And if they can rely on the local judiciary system, that is a huge advantage for every investor. So this was, I believe I'm to the end of my given time. I brought here some examples of scorecards that can be used. I believe that you can share it with all participants that put by it's WAVTEQ source. So they try to put, and usually banks use it, as they have to see the organizational strategy very clearly, and you can see the list of the things that you need to reassess, and being local as the nation who's attracting investment. And there's aftercare, also the policy scorecard. It gives you clear understanding what questions you need to be asking and what directions you have to be working on. And then lastly, about monitoring and evaluation of your FDI. And these also help clearly understand what steps can be taken, and how you can work on monitoring, what you can look at, what factors, what you can see the question number 2, are there clear FDI result targets, number of FDI projects, jobs, capital investment? You all need to look at this spectrums when you're working on basically investment promotion and protection. And I try to give here small perspective that governments not need to only focus on international investment law as the protection for investors, but also they need to look at their whole policy making and take into account all of these other things that really matters. Thank you very much for giving me time to speak about this topic, and I'm happy to answer any questions.
Thank you, Anat. I hope you can hear me.
Yes.
Okay, good. So thank you so much for this very informative paper about the options related to state policy making that in relation to investment promotion and protection, and informing us that there are options that are not just related to BITs and MITs, and especially the example of Brazil. And also the reminder that the first BIT was signed between Pakistan and Germany, which is my home country of origin. Fun fact, the first computer virus was also developed by Pakistanis, but that has nothing to do with this. But anyway, we are now going to take questions. And I mean, we had originally planned for 15 minutes, but it seems that we are just running out of time, going over time anyway. But let's keep it to 15 minutes. If not, I mean, there's nothing I can do about it. There was already a question for Mr. Rostambekov from our research department, but he seems, I mean, he has left, so I don't know what we should do with that question, and I apologize to the people at research. I'm sure other people would have had questions for him as well, but any other questions, happy to take them. Pardon? Is there anybody who has questions? Please raise your hands and we will pass on a mic to you. Finish? Okay, no questions for anybody? Yes, only for, sorry, only for Islamic, it seems like it. Okay, so thank you everyone for joining. Please join us tomorrow as well. We will have some very interesting papers lined up. And with this, let's end this evening. Thank you. Goodbye.
Thank you.
Yes.